Tribunal with that Nagar matter, they are acting like a ruling juggernaut. I have submitted documents, they are not giving any hearing, and they are, I mean, demolition.
You're mentioning upon notice.
I shall mention upon notice at 1:15 if you lordship permits.
No. We will list it on Monday, subject
I
to.
filed it yesterday.
If you can, or we can keep it under the caption to be mentioned on Monday.
On Monday, lordship, can it be done on today? Because
today,
this weekend they will.
Today,
Monday.
Monday we can do it. But actually, what happens is we have already given a date. This will amount to advancing the date without notice to them.
I shall serve notice.
To serve notice, it will come under the caption to be mentioned. Let us see what happens.
On Monday. Lordship.
My Lord, prayer for the listing of Costa 3 and 4 of 2025, my Lord. On last Wednesday, my Lord.
Department is not able to send the file because there is some defect.
My Lord.
Please rectify the defect, it will be listed.
My Lord.
Yes?
It's for this only.
Oh, no.
Or yes, sir, daily matter item number 1.
This is my application, my Lord. 300 days delay. We have already served. Twice it has been served. And they have, do you have the track record? The affidavit service is not ready for the second service, my Lord. In course of today, Mr. Sharma will be filing the affidavit service, but I have the track record. The item was delivered on 6th of February, my Lord.
Yesterday.
Yes, they've received it.
Earlier it was said,
But
it was written back.
Written back with the endorsement.
No such person at the address.
No such company in that.
Mr. Sunil Surana appeared for the assessee before the tribunal. All right, we'll condone the delay today. We have heard Ms. Smita Dasde, Amit Sharma. Respondent has been served. Affidavit of service has been filed.
In course of today.
One for affirmation, my Lord.
All right, affidavit has been filed, but none appears for the respondent. There is a delay of 300 days in filing the appeal. As the delay has been explained and the reasons given are acceptable, the delay is condoned, application is allowed. You can inform Mr. Surana,
yes, ma'am,
whether he will be able to.
Item number 2.
May it please, Your Lordship. There's a delay of 57 days in preferring this appeal.
Respondent served.
Respondent service.
The item delivered on 31st January 2025.
All right, we have heard Mr. Tilak Mitro, submission, Mr. Soman Bhattacharya. The respondent has been served and affidavit of service has been filed, but none appears for the respondent. There is a delay of 57 days. Same thing. Delay control application allowed.
I'm extremely grateful, ma'am.
Item number 3.
My Lord, item number 3, 4, and 5. Service is not complete, my Lord. Kindly fix the matter after 2 weeks.
All right, list after serve.
Grateful, my Lord.
Item number 6.
My Lord, in item number 6, Mr. Kaushik Day and Mr. Tapan Banjo is appearing. Mr. Kaushik Day is out of Kolkata today.
Delay has been condoned already.
Yeah. Only
delay has
33 days. 33
Not condoned.
Not condoned.
Only 33
days delay.
Not opposing here.
The previous 3 items also there is a delay.
Lordship, yes, Your Lordship. I have brought the numbers of the 3 items. Your Lordship, kindly those 3 items may be done.
This is connected matters.
Connected matter, Your Lordship. Actually, Your Lordship, this is a appeal against the company. Those are appeals against the personal penalty.
You have heard so and so, so and so. There is a delay of 33 days, delay condoned. This is the appeals along with CUSTA 101, 102, 103 of 2024. Yes.
Number 7,
Not I beg to appear on behalf of
Seven,
the
my lord,
appellant,
I
my lord.
appear for the respondent. Delay of 120 days. May I kindly see the reasons for the delay. My lord, I'm strongly opposing the my lord condonation of delay petition. Strongly opposing.
It is my application, my lord. Let me, my lord, move, my lord. It's my application. Let me, my lord, move. My lord, this is the appeal filed by the Southeastern Coalfield Limited, my lord, which is, my lord, situated at Chhattisgarh.
Hmm.
My lord, what has happened on 9th of July 2024, on ex parte interim order was passed by the learned single judge.
Hmm.
Thereafter, my lord, we have, my lord, moved an application for vacation of the stay on invocation of the bank guarantee as granted by the learned single judge. On 6th of August 2024,
Hmm.
this my application for vacation of stay was, my lord, rejected.
Hmm.
Pursuant to that, at that point of time, my lord, the erstwhile advocate was engaged by the Southeastern Coalfield Limited. So, my lord, thereafter, my lord, several correspondence, my lord, have been exchanged between them, asking the erstwhile advocate to prepare and file the appeal.
Not a
There
serial
was,
document
but
annex.
there was, my lord, some difficulty for which, my lord, they could not file the appeal within the time. Now, my lord, kindly comes to
Lordship, may I
page,
kindly
page,
interfere? Lordship, may I kindly interfere? I'm on behalf of the respondent number 4, ICICI Bank. My senior is on his way. Kindly grant a short pass over.
no, kindly come to ICICI Bank, my lord, for the present, it may not be, my lord, required to be represented. No, kindly comes to page 19. That is the, my lord, letter of engagement, my lord, given to this present advocate on record.
19 of
19 of the stay application, 19 of the application for condition of delay. As directed by the competent authority, you are requested to please file an appeal and also reply to the main writ petition. The matter was alerted to Mr. So-and-so, who is not cooperating in terms of the handing over of the file, and hence necessary documents on express basis may be sought and filing to be done. My lord, when we have been, my lord, engaged, our advocate on record was engaged, my lord, we didn't have the single document, for which, my lord, we have applied for this obtaining the certified copies of the record on 11th of November. Then, my lord, every document was handed over to us on, my lord, 24th of November, and on my lord, on reopening on 2nd of January, my lord, we have filed, my lord, this appeal.
And what is on the merits of the matter?
Merit, my lord, I'll tell you, my lord, invocation of the bank guarantee was, my lord, state.
Rejected.
my lord,
State.
kindly come
No,
to
no.
page 94.
Let
I'm just
me, my lord, move.
Hmm.
My lord, I tell you, lordship, what has happened. Southeastern Coalfield, my lord, floated a tender through government e-marketplace for the purpose of supply of breathing apparatus. Your lordship is well aware this breathing apparatus, my lord, is used for the purpose of mining and for the purpose of, my lord, rescue operation. So that if anything, my lord, goes wrong, and this breathing apparatus, my lord, helps the person to be rescued. Now, my lord, what has happened? So they invited this tender for the purpose of supply of this particular material. So, my lord, this company has participated in the bid, showing that they had prior experience in supplying of such kind of materials. Now, thereafter, my lord, subsequently, my lord, we came to know from another subsidiary of Coal India, that is Eastern Coalfield Limited, that they have also participated in ECL's tender using similar certificate, and pursuant to which this ECL has, my lord, written to the concerned authority who has issued such certificate. That authority in Ukraine has given an affidavit which has been apostille, saying that certificate was not issued by them. So on the basis of false and
It's a forged document.
forged document, my lord. Forged document. And, my lord, what has,
So you cancel the tender.
my lord, they have, my lord,
I was
They
the
have-
unsuccessful bidder.
they were the unsuccessful.
Then we'll
bidder.
grant an interim order. No, then we'll grant
No,
an
no, I
interim
was
order.
just assisting you.
There should be some decorum.
Hello,
Please
I'll-
take your seat.
My lord, what has happened? They have participated in the tender process. They have submitted EMD in form of the bank guarantee, and when there was reverse bidding, they have withdrawn themselves from the bidding process.
Hmm.
But our tender condition says that if you have participated in the tender process, and if you have submitted false document, it can be, my lord, forfeited, irrespective of the fact irrespective of the fact
Withdrew from the bid.
they withdrew from the bid or not, because your participation was allowed on the basis of such certification. Otherwise, you are not even eligible to participate. Now,
But then,
leaving that, another important aspect. This court, my lord, did not have any jurisdiction to entertain this writ petition at all, my lord. My lord, I will show, my lord, what a malafide action they have done to take the jurisdiction of this honorable court. One kindly comes to paragraph 10 of their writ petition, page 128, volume 2. I'll show the malafide intention, my lord, what they have done to get the jurisdiction.
yes,
Para 10, my lord, they are saying, in the circumstances, the quotation submitted by the other qualified bidder was accepted and the contract bearing number so and so came to be awarded in favor of Shubhajyoti India Private Limited. Such award of contract in favor of the Shubhajyoti Private Limited was made upon ignoring the representation made by the petitioner as against the incorrect and erroneous documents submitted by the Shubhajyoti India Limited in support of such deed. Now, my lord, kindly comes to para 36, where they have pleaded that why this court will have jurisdiction to entertain this writ petition. Para 36, my lord, is at page
150.
150, my lord. 150. Your petitioner says the submit that the e-tender was floated by the respondent number 2 on JM portal from its office outside the jurisdiction of this honorable court. The offer submitted by the petition number 1 company from its city office at 50 Chourungi, so and registered office at Modurima House, Chandima Moldik Road, Kolkata 732 was accepted by the respondent number 2 company, and a contract was issued by the respondent number 2 by email, which was received by the petitioner number 1 company at its city office 50 Chourungi, 6th floor, and the registered office and Modurima House 83 and 84, Chandina Main Road 7,15,000, wherein a valid binding contract and concluded contract came into existence. Pursuant to and in the terms of the said contract, petition number 1 company caused a bank guarantee to be issued by its banker, the respondent number stored, having his office at so and so place within the jurisdiction of this honorable court. Now, my lord, first, my lord, they lie that they have received a contract, where, my lord, it is their averment. They have not been awarded the contract. Now, my lord, assuming that they have received contract, or they have received any communication with regard to this transaction, then also, my lord, that do not, my lord, form any part cause of action. Honorable,
two issues. One is the registered office of the writ petitioner is in West Bengal.
my lord.
The bank which issued the guarantee is in West Bengal.
Yes.
He was allowed to participate, and the tender was awarded probably by online mode or by
My
some
lord.
communication receivable by the writ petitioner who is in Calcutta. So at least part of the cause of action has arisen here. No?
My lord, I bow down to what has fallen from your lordship. My lord, I am carrying
No.
judgments.
Before that, no. The issue is the writ petition is still pending. Number 2, you are alleging fraud. That needs to be adjudicated. No? That one company, the Eastern Coalfields, has written saying that this document was produced in another tender, and that certifying authority has said that he has not issued.
Yes,
but that issue has not gone for adjudication before any judicial forum. For the first time, the court will see whether this document is a fraudulent document or whether the issuing authority was correct in saying that they have not issued it. What is the purport and intent of that document? That is why the learned judge says that we need to go into that.
No.
And if you invoke the, of course, rarest of rare cases, a bank guarantee will be injuncted. But one of the rare circumstances is case of fraud. Fraud needs to be proved beyond reasonable doubt.
Now, I am very much grateful to your lordship here, as lordship has correctly pointed out. To restrict invocation of bank guarantee, it is the, my lord, the party seeking restraint on the invocation has to prove that there is a fraud. Burden is
so therefore
but they have to
suppose assuming there was some criminal case lodged against the issuing authority or Eastern Coalfields has proceeded against them. They went before the court and the court adjudicated it and found the document to be false. You are armed with that judgment. And then with the same document, if he has participated, we can say that there has been an adjudication. But till now, that for the first time, this court will adjudicate whether that document is a fraudulent document or the document was intended for some other purpose or interpreted in a wrong manner. All those issues need to be, and if you invoke it, the writ petition will become infructuous.
My lord, as you
If
lordship,
you have filed your affidavit in opposition, we will request the learned single bench to hear out the matter within 2 weeks.
two issues, my lord, then they are subject to, of course, what your lordship would say.
So we are very clear in our mind that bank guarantees should not be injuncted.
My lord,
Several decisions are there. But when you plead fraud, let us see your order which was impugned in the writ petition.
yes, my lord. My lord, kindly comes to page, my lord, page in volume 2.
15th June 2024.
Only volume 2. No, my lord, 6th August, my lord. It means 6th August.
6th August.
6th August, my lord. Kindly come to page 171, my lord. 171.
No, this is the impugned order.
Yes, my lord.
What was challenged in the writ petition, if you come to the prayer in the writ petition,
Yes, my lord.
page number 153.
153, yes, my lord. My lord, in page 153, my lord,
Or
what they have
154.
challenged that invocation.
Yes, you show
Invocation,
that letter.
invocation was sought on 15th June 2020.
You show that
Yes,
communication.
my lord, I'll show to that. In that, my lord, in that invocation letter, my lord, we have not cited the specific ground on
So you would have directly written to the bank.
we have written to the bank. Now, my lord, what has happened in 9 July, we have, my lord, specifically written the ground as mentioned in the ground.
Please show that.
9 July, second letter, that. Second, 172. No, এখানে or kindly come to page 175. 175. This is the latest invocation.
No, not this one. Not this one.
আমি দেখাচ্ছি ওটা 15 জন আমি
লাগাওই নি writ petition.
No, where is the notice issued to the
Yes.
writ petitioner saying that you, because of this, we are invoking the bank?
We have not issued any notice to the writ petitioner. If so far as bank guarantee is concerned, bank guarantees and
No,
for the first,
for the first time in your application for vacating the interim order, you have pleaded this case.
yes. Because on 9th of July, we were not heard, my lord. We are not there when the first interim order was, my lord, passed. We didn't have an occasion to place this, my lord, 9 July later.
Now, please show the first interim order according to you, ex parte interim order.
Yes, my lord. First interim order. No,
94.
Page 94. Can you come to page 94? Under single judge, my lord, was of the opinion none of the condition for invoking the bank guarantee was met out. On reading the, my lord, 15 June 2024 letter. In 15 June 2024 letter, my lord, admittedly, my lord, we have not assigned any reason, or we have not, my lord, invoked any ground.
Yes.
And my lord, subsequently, my lord, we have been, my lord, informed by the ECL that this document is, my lord, forged.
See, despite service of notice,
Yes. So, my lord,
repeated notices, you did not appear.
so, my lord, I am
Wait,
not
wait.
alleging that.
In the second order, which is impugned in this appeal,
My lord.
please come to page 172.
Yes.
About 7 lines from the top.
Yes.
The bank responded to the settled letter asking the terms team to process the matter on the basis of original letter. In the meantime, order was passed by this court on the basis of communication of the Southeastern Coalfields dated 15th June. It had been recorded in the earlier order that documents had been produced by the bank which shows pursuant to letter of 15 June, the bank had rejected the claim for encashment of the bank guarantee. The
Right.
first letter of the bank also indicate that the bank had refused to invoke the bank guarantee if the some bank guarantees are conditional, some are unconditional.
Right.
If it carries a condition, then the unsuccessful bidder who sought for return of the money or return of the bank guarantee should be put on notice. How do you take him by surprise saying that you are alleging fraud? It's a very serious allegation. The best course open to you is you have missed the bus at the first instance because learned judge says repeated.
Right.
And this is all. You file your affidavit in opposition within 2 weeks. We will request the learned single bench to take it up. If you do it, probably first week of March, we'll.
My lord, two things, my lord. In the meantime, what has happened? Bank guarantee, my lord,
Has lapsed.
has lapsed.
Matter is over.
Now, my lord, your lordship is well aware, my lord, restitution is possible. If my lord, your lordship holds that the order granting stay was not proper.
We'll say you keep your bank guarantee alive.
No, my lord. My lord, kindly see.
Now, my lord,
My lord, the
What do you say?
fact
No, no,
has
no.
been
No, no.
misplaced before your lordship, my lord. May I?
Bank guarantee, when did it expire?
My lord, it's before.
my lord, 9th
Not
of
before,
July,
my lord.
my lord, 9th of July, stay order was
My lord, according
12th July, my
to
lord,
the
is
GEM
expired.
portal, my lord, GEM portal, the bank guarantee should have been returned to me within 15 days.
That is on merits.
My lord.
When you please tell the first extension when it was granted,
Yes.
when it lapsed.
Yes, my lord.
My lord,
Yes.
9th July,
No.
it was, my lord, lapsed on 12th July. That would, my lord, appear from the
12th July.
12th July, because my lord, 9th July, my lord, interim order was passed. It was valid till, my lord, 12th
All
July.
right, please come. This intra-court
Bank
appeal,
guarantee. My lord, may I?
the respondent in the writ petition is directed against an interim order.
My lord, may I submit, my lord?
We'll learn at civil bench. Here, sir.
Very well.
Otherwise, we'll grant an interim order.
No, very well.
Against an interim order passed by the learned single bench in WPO 594 of 2024. As could be seen from the first order dated 9th July 2024, passed by the learned single bench, the appellant herein who was the respondent in the writ petition, namely the tendering authority, despite issuance of repeated notices and communication, did not appear before the court, nor the bank was present, and the court took into consideration the facts and circumstances, and having been prima facie satisfied, granted an order of stay for a limited period of invocation of the bank guarantee. Subsequently, the appellant has filed an application for vacating the interim order, which was considered by the learned single bench, and the interim order and the said application was rejected. Agreed by the same, the appellant are before us. Firstly, we need to point out, we are clear in our mind about the legal position that court should refrain from granting an order of injunction or stay from invocation of a bank guarantee. However, this rule, which has developed through various judicial decisions, has certain exceptions. One such exception which we can point out is when there is an allegation of fraud. According to the appellant, the writ petitioner had produced a certificate of prior experience to enable them to participate in the tender invited by the appellant. According to the appellant, the said experience certificate is a fraudulent document And in this regard, they seek to rely upon certain communication sent by Eastern Coalfields Limited. The learned single bench took note of the facts and circumstances of the case which were placed for the first time before the court in the application for vacating the interim order and opined that the allegation of producing a false or fabricated or fraudulent document needs to be examined. One more issue, one more matter which needs to be taken note of is that the writ petitioner was not informed that the reason for not returning the bank guarantee, despite the writ petitioner being an unsuccessful bidder, was on account of the allegation that the experience certificate is a fraudulent document. The learned advocate for the appellant would submit that in terms, as per the terms and conditions of the bid document, if it is found by the tendering authority that the information furnished is by the tenderer is false or any fraudulent documents has been produced, they have got a right of forfeiture of the amount furnished by the tenderer, which is given in the form of a bank guarantee. Thus, several issues need to be adjudicated, more particularly when there is an allegation of fraud. Therefore, we are of the view that the learned single bench was justified in granting an interim order. One more issue which we need to point out is that the bank guarantee which was given by the respondent writ petitioner had lapsed on 12th of July 2024. Thus, we find no grounds to interfere with the impugned order. The appeal fails and is dismissed. If the appellant is directed to file the affidavit and their affidavit in opposition within 3 weeks from date and reply, if any, within a week thereafter, after which the appellant is granted liberty to mention before the learned single bench for taking up the matter on an earlier date.
Not only one problem, let them renew the bank guarantee. Restitution is possible, not yet.
You succeed.
Not only one observation, only restitution. Let them
It cannot.
I will not invoke. I will not invoke till the pendency. I will not invoke till the pendency.
Thank you. Next.
Item number 8.
Yes, sir.
My lord, we've come back with one more round. My lord, this, if your lordship recalls, there were 5 separate writ petitions by which we challenged classification of the petitioners, which were principal borrower, promoter, directors of the principal borrower company, guarantors and corporate guarantors, 5 separate writ classifying them as willful defaulters. My lord, all the 5 writ petitions were disposed of by a common order.
And one matter we allow you to file a review.
So then, my lord, it was dismissed. There were 5 separate appeals. My lord, thereafter, it transpired that one of the appellant, he claimed that he was not a director at that relevant point of time, that relevant financial year. So, my lord, your lordship gave them liberty to file a review application. My lord, thereafter, 2 more appeals, one by another additional director and one by a corporate guarantor. Similar liberty was given. So those 2 appellants also withdrew their appeal pursuant to your lordship's order, filed review application. My lord, so far as this present appeal is concerned, it is an appeal by a corporate guarantor to the principal borrower company. So the corporate guarantor filed a review application on the ground that there is a clause, my lord, clause 2.6 of the master circular, which indicates or which contemplates the manner in which a corporate guarantor is required to be classified as a willful defaulter. What are the events of default? So we said that this was specifically taken. Show cause notice does not provide any of the grounds. The first committee as well as the review committee does not take into consideration or does not give any reason while classifying the petitioner as a willful defaulter. Well, in the review application has been heard, has been dismissed on merits. So, well, we have 2 appeals now, one from the order passed in the review application and one from the original order.
Against the review application, the appeal is within time.
Within time.
The other one is 700 days. Respondent served.
Served. Affidavit of
And
service.
who will appear?
My lord, affidavit of service, my lord, they were appearing at all time, but today they are not.
What happened to the other 2 appeals? totally five.
They are still pending before your lordship. There's an interim order which your lordship has been pleased to pass, and they are pending adjudication. Final hearing is pending. The order.
But can
Madam,
you,
we've annexed those orders as well to my
no, can you
application.
bring at least Mr. Anirban?
Yes,
Paramik?
my lord, what we did is that we initially served him notice, but he refused to accept notice and he requested us to serve upon the bank. So we served upon the respondent banks.
And what was the interim order granted in the earlier?
My lord, not to publish the photographs. This was the interim order passed by your lordship in appeal.
But here is a corporate guarantor. that
Corporate
issue-
guarantor. My lord, what they do is usually is the directors of the corporate guarantors, their photographs are published. Because unless there's a specific order, it is impossible
But
to
then
stop the
first,
banks.
First, we have to condone
My
the
lord, the delay,
701.
the delay.
It's better we hear them. No? Can you bring? He is refusing to appear. No.
He has. My lord, we attempted to serve him. He said that I will not accept service, serve upon the bank.
On
Because
what date bank it was? Sir?
Thank you have served.
yes, we have filed the affidavits of service. The copy the. No, they have received it on the 5th of February. 5th February.
Next week we list it.
Very well.
We have heard Mr. Mainak Bose, learned senior advocate for the appellant. Notice was served on the respondent bank on 5th of February 2025. It is submitted that the counsel on record for the appellant attempted to serve notice on the counsel who appeared for the respondent bank in the connected appeals, but however, he has expressed inability, certain difficulties in accepting notice. Since connected matters are pending before this court, in which the learned advocates are appearing, we direct the learned advocate on record for the appellant to serve notice on Mr. Anirban Paramik, Mr. Pramanik, and Anirban Pramanik, who had appeared before the learned single bench for the respondent bank, as well as who is appearing in the other appeals which are pending before this court. List the matter next week.
Mr. Bose, whether an appeal lies against an order rejecting a review application.
Well, there are one set of judgment says yes, it does, but the other set says may not be maintainable. Well, but
Only the parent order which is to be challenged.
so, my lord, that's why we filed two separate appeals. One from the
Not necessary.
No.
It's the parent order which is to be challenged,
that is
not
challenged.
the order.
So, my lord,
rejecting the
even
review
if we lose on the point of maintainability, my principal appeal is there with the section 5. That is there. But I will still try to
application.
satisfy your
Necessary
lordship.
to prefer an appeal against an order rejecting a review
Review
application.
application. My lord, one set of judgment says the specially petition lies. Intra-court appeal may not lie. Well, we'll try and satisfy your lordship if it does.
That issue is also pending.
Hmm.
This issue has been raised.
Item number 9 and 10.
This item also 9 and 10, Mr. Kaushik Day is appearing. Madam.
Not today.
Item number 11. Item number 11.
Yes. APOT 5 of 2025 and APOT 314. So we have to take up the government's appeal first.
No, my lord, WBID's appeal. My lord, because in the WBID's appeal, my lord has already condoned the delay.
Okay.
WBID's appeal.
Item number 12.
Yes.
So we have to take up item 12.
Yes. Led by Advocate General, may I start?
You start, I think AG was here.
Yes.
You start. giving us
Friday is
some-
a bad day for contempt matters. All the.
You just give us
Yes.
some facts.
My lord, my
But I have got this point, my lord.
lord, may I indicate the facts? My lord, here it's a case.
Sit down, sit down.
They were considered to be a mega unit, and special packages was
Mega unit.
mega unit. Special package was given to them, under which 70% of the sale tax was to be refunded to them once they pay.
70%
Of the tax,
which tax? Sales tax.
sale tax, my lord, was to be refunded to them. And here it is a case, my lord. Our promise to pay is preceded by their promise to invest 400 crores. I'll show the sanction letter where they have, that was premised under the situation that they have to invest 400 crores. They have to build in 3 different districts, the industries and these products. My lord, the letter under which they have made the application is not on record, but their pleadings to that effect, what they had applied for. Now, admitted position is they have not invested 400 crores and not started any industry in one of the districts. Admitted position. Now the question is, my lord, whether we still have to continue to make payment on the basis of that promise which was made in 2004. That sanction letter. My lord, the Honorable Single Judge proceeds on the basis the definition of mega unit means minimum threshold limit is 25 crores. Once they invest 25 crores, you have to go on paying. If they do not make those products also, that will not be an impediment for you to make the payments. But this is the case, short term. Malad would kindly come to the scheme. Malad,
Yes.
first.
To show us the package.
Yes, Malad, package. Malad, may I show the scheme?
Yes.
Which starts from page 58.
West Bengal incentive scheme.
Yes, Malad, 2000. Malad would find Roman 13, 2 Roman 13 is the definition clause, mega unit.
Page 58.
Yes, man. 59, man. Mega unit means an eligible unit of special characteristics set up on or after 1st January 2000 with investment exceeding rupees 250 crores / 25 crores with effect from 1st July 2001 with a notification. So minimum threshold is 25 crores as on date from 1st July 2001.
Yes.
Yes. My lord would kindly now kindly.
Just one interjection. And I'm appearing for the respondent here. And let the appellant conclude his submissions, my lord. Would your lordship kindly give me time on some day to give reply, because this one matter which is going to be taken up very urgent subject.
Because the AG was saying some contempt is there. That is why we have the problem is,
yes,
his lordship has also got other division benches. Once this gets spilled over, it becomes very difficult.
Very well, my lord.
Or we have it on Wednesday. Second half will be.
Yes, Wednesday, second half.
Well, let it remain in the position then, my lord.
Yes. Subject to fresh applications. Suppose we say not today, automatically it will come on Wednesday.
Wednesday. My lord,
subject to convenience of AG and senior.
All the senior advocates accepts, my lord.
Second half, my lord.
Second half only.
2 p.m. to
2 p.m.
origin said to 2 p.m.
All right. We'll say not today.
But my lord would record that we have started the argument, because on by any chance on Wednesday is not taken up.
My lord,
Friday is
the item was taken up. My lord, I informed the court that the appeal is listed today. I have not opposed their prayer. I have not opposed their prayer for adjournment.
There are 2 appeals challenging a common order. challenging the same order passed by the learned single bench. The arguments on behalf of the appellant in APOT 314 of 2024 has commenced. Due to certain inconvenience for the learned senior advocate appearing for the respondent writ petitioner, the matter stands adjourned to Wednesday. Let the appeals retain its position. Wednesday, same position.
I'm grateful, man.
And only my lord, one humble prayer. Let it be by consent of the party, because my lord, once, otherwise, my lord, if the matter is made return, contempt is made returnable on next Friday. Suppose my lord, if the matter is not.
No,
taken,
Wednesday we will deal with it. Nothing.
I'm grateful.
Grateful.
Item number 13.
Sir, I appear on behalf of the appellant.
Your
Passport matter.
only prayer I am making. I have taken the consent of Mr. Sengupta.
No consent.
Not Mr. Sengupta. Mr. Sengupta Junior. My learned junior, Umanjyoti theory is out of session. The judgments and all documents are lying with him. So he has agreed for a specific matter to be heard on Wednesday. So the writ petition has been dismissed. If it is taken up after 3-4 days, nothing will happen.
Yes, it happens because I tell you, Lordship, it relates to grant of passport. Delhi High Court said yes, passport may be granted for 10 years. The criminal court, NIA court, that also said yes, because passport is expiring. There is no reason why.
But writ court said no. But the writ
The question is, after Delhi High Court's order, would the writ court sit in appeal over that? Because Delhi High Court's order has to be complied with by the passport authorities. Now, passport authorities, by declining to grant reference, and that too orally, when I come here, can this learned judge sit over the propriety, validity of the order of the division, Delhi High Court? And I came to court, this court, alleging inaction on the part of
Delhi High Court granted permission, directed no objection to be given. But the trial court, the NIA court or dealing special court, it has not granted permission.
Yes.
There are two cases pending. In one case, no objection has been opted.
Yes.
The other case, no objection has not been opted. Section 6, subsection 2 F of the Passport Act provides when there is a pendency of a criminal case, no passport shall be issued. Now, with regard to this provision, in exercise of the power under Section 22 of the Passport Act, the central government has issued a notification giving liberty the benefit of getting no objection from the criminal court in the event they want to go abroad. Now, his renewal case has been rejected, has not been granted. The petition has been dismissed. If it is taken up on Wednesday, I do not know why.
Kindly come to page 36. My learned friend is saying something which is off the record.
No, nothing.
Kindly see page 36. What is the other case? Nothing has been disclosed. That there is another case. Kindly see page 36. Second paragraph. Considering the above facts and circumstances, passport of the petitioner being such and such is directed to be handed over to the petitioner for limited purpose of renewal on furnishing indemnity bond of which such and such with two sureties, cash like that. Petitioner is also directed to remain physically present for failing of on such and such day himself receive the passport and will be undertaking that he will not obtain visa to travel outside India after renewal of the passport without permission of this court, and he will deposit the same to the court. Okay. So, if the passport is issued, I cannot leave without the permission of the court. Now, kindly see Delhi High Court's order. Kindly see Delhi High Court's order. Page.
11 না ওটা হচ্ছে দিল্লি হাইকোর্টের অর্ডার হচ্ছে 37
next page, I'm sorry.
37
Yes.
ওল স্ট্যাম্প কেসটা স্টে করে দিয়ে এটা দিচ্ছি
Not page 37. Kindly see paragraph 2 first. This court by the order dated 23rd May 2022 suspended the sentence of the applicant
with the
with the direction that the applicant shall not leave the country without permission. That will not
39.
kindly come to
39.
page 38, paragraph 4. It is stated that the passport of the applicant has expired on 28th August 23, as per the notification dated 25th August 23, and memorandum issued by the ministry are required to take no objection permission from the concerned court for renewal or issuance of passports. Hence, the present application has been filed, seeking no objection. Then we not.
No, sir. Sorry for interruption.
Yes.
This is an appeal against a judgment convicting the appellant.
Yes.
Under section 120B, etc.
Yes, yes.
11, page 11.
As against the order passed by the special judge NIA Ranchi, no appeal had been.
Yes.
Where is the order?
Yes. That's pending there. I have been granted bail by the appeal.
No, against this order,
Two
which is
cases.
a conditional order, that for the limited purpose of renewal, you will have to furnish an indemnity bond, give your passport for renewal. On obtaining renewal, deposit the passport in the court's office, and with an undertaking that you shall not leave the country. So this order needs to be modified. If as long as this order is not modified, you are before the special court.
Yes, but I can. My passport has to be renewed, but I cannot leave.
That's true, sir. There are two cases.
Two cases.
Yes.
There are two criminal cases.
Yes.
One case he has been convicted. The other case is being tried
Right.
by the special judge. So this order passed by the Delhi High Court will not help the appellant.
Kindly.
It won't help the appellant. One thing can be done. We can grant permission to you to file an application before the special judge. See, your passport is already renewed, sir.
No. That is the prayer.
No,
Just sitting tight.
The page 36 in here has read this direction. As long as this direction remains, that you are entitled for renewal.
That's why.
But how do you file a writ petition in the Calcutta High Court
No.
saying that supersede the order passed?
No. The authorities are here in Calcutta.
Passport authority.
Passport authority.
Maybe, but
they are.
This writ petition cannot be an appeal against the order passed by the special court.
No, it's not.
Inaction.
It's inaction. Repetition.
No.
The authorities here.
As long as this order remains intact, the appellant cannot vary this condition passed by the special. You seek for varying this condition?
No, we are not.
I do not want variation. I want this order to be implemented.
No, it's not implemented. You go before the special court.
But kindly see the passport authorities.
What is the stage of the trial now? Whether charges have been framed?
This matter.
Trial is continuing.
Trial is continuing. Trial is continuing.
Then automatically you can, once trial has commenced, you can always say, tell the court that this is required to be done. Where is the order passed by the regional passport authority?
No order passed. I go and say, no. This is my grievance.
Court demand
But
justice.
I understand. If the authorities say for X, Y, Z reason, we will not renew your passport.
Demand justice.
Nothing has been said. I have written 4 times to the authorities.
43, 45, 47.
And they sit tight. But question is, can a statutory authority sit tight over a representation where I say that courts have granted me permission? No objection from the court has been obtained. Please renew me. They say, nothing. Sit tight. And when I come to court, if at that they have not disclosed any order, but when is the order? Then your lordship could have judged the validity of the order on the touchstone of Article 14, Article 16, Article 21. Otherwise, an authority will sit tight, won't write anything, and say, no, sorry. We can't. Why? Lord, it is precisely for this query we have come to this court. Not that I am asking for any contempt of the authorities. I am saying, my lord, there is an order. Kindly direct the authorities.
To dispose of my application.
Kindly see the prayer.
Read petitioner prayer.
Kindly see the prayer.
Read petitioner prayer to এখানে নেই।
Under the provisions of
Yes.
the Passport Act,
Yes.
Read petitioner.
where is there any provision or any section or rule saying that no objection certificate has to be obtained?
It's under the notification of the government.
Yes.
It's under the notification of the government.
Power under the Passport Act, they have got a power to even revoke the passport, suspend the passport.
Yes. For valid reasons. Not arbitrarily. Not arbitrarily.
Read prayer বলে। Read prayer
No, I have got one preliminary submission. The conviction has not been stayed by the Delhi High Court.
That doesn't matter.
And yes, it matters. It matters. The Passport Act says if there is conviction, he is not entitled to passport. And he's saying, my lord, I am submitting off the record. Kindly ask him to place his paragraph 6 of the writ petition. He did not get no objection from the NIA court.
Yes, I have
Two cases.
There are two cases. One case, conviction having been made, we went to Delhi High Court.
Conviction by suspension of sentence, conviction is not stayed.
Certainly not.
So the stigma is still attached.
Yes.
There is an embargo.
Suspend the
If a
operation of the
person has been
sentence.
convicted under the Passport Act, which provisions are?
Section 10, section 10, my lord.
Now, if your lordship kindly comes to page 29,
10(2)(d), section 10(2)(d), I'm handing over this Passport Act.
29.
kindly come to page 29 once.
দুজনে একসাথে কি করে? এটা হচ্ছে যখন অ্যাপিলটা অ্যাডমিট হচ্ছে।
Lord, in the facts and circumstances, now your lordship says
Page 29.
punishment has not been suspended, sentence has not been suspended. Yes, page 29. In the facts and circumstances of the instant case, it is considered appropriate to suspend the operation of the sentence.
Correct. Conviction stays, sir.
Lord,
Sir, that is.
certainly
the
conviction,
Supreme Court has settled that issue.
I fully appreciate. Lord, the conviction remains, but that does not debar the court, Delhi High Court.
Section 10(2)(d), if there is conviction, he is not entitled to passport.
37.
Section 10(2)(d), my lord.
37. We have suspended the sentence.
No objection to
Therefore, there is no basis for not reviewing the passport, renewing the passport.
they can file appeal.
ঠিক আছে, এই তো দিল্লি হাইকোর্ট তারপর ওই অর্ডারটাকে টেনেই বলছে। 38. Present case, it is also noted in the order suspending sentence. মানে ওটা করার পরও করা যায়, কনভিকশন ইয়ে না করবো। খালি ওইটা সব্যসাচীর অর্ডারটা পড়ে একটুখানি
Pendency of the criminal case.
They can file appeal. Lord, yes, I shall draw your lordship's attention. Kindly come to page 38. Delhi High Court's order. Kindly come to page 38. What fell from your lordship was really considered by the Delhi High Court. Paragraph 7, page 38, bottom.
But how will you get over this embargo of section 10(3)(d)?
I put it this way. Lord, an order has been passed. One can say, before that court, in view of 10(3)(d), you cannot. It's one thing. Another thing is, I'm a statutory authority. In spite of the Delhi High Court's order, I shall not do it, nor shall I disclose why I am not doing it. I understand, Lord, the passport authorities coming and saying that in view of 10(3)(d), I cannot go. I'm going to Delhi High Court.
This is for new passport, sir.
I'm going to Delhi High Court.
This is for new passport.
If they want,
The day for new passport, judge is saying new renewal is a new. It is a new passport. Tenta.
Sir, Passport Authority was not a party before the Delhi High Court.
it doesn't have to be. Because
Obviously, it has to be.
because
He is the issuing authority. He needs to be heard. Without him, some direction is issued. Sir, what happens is if your writ petition is allowed, it will tantamount to varying the order passed by the special court, whereby you are restrained from using the passport except for submission for renewal.
yes, without permission I can't leave.
All right.
That's it.
One more thing.
Yes.
The NIA court did not put the regional passport authority on notice. They were not parties to the matter. Is it they are governed by a special statute. They can't be bound over by some direction issued by a special court in a proceedings to which they were not a party. And above all, sir, the writ petitioner has been convicted.
Yes.
Suspension of sentences, he need not undergo the sentence. That's all.
Yes, the conviction.
Conviction stays.
Yes.
The conviction stays. Sir knows about better about the service jurisprudence. If there is a suspension of sentence, that does not mean the charge proceedings have to be dropped.
The conviction has not been stayed.
Not stayed.
Kindly come to section 10(3), as your lordship was referring to. Kindly say, what is that say? The passport authority may impound or cause to be impounded or revoke a passport or travel document under these conditions. Now, my passport has not been impounded. My passport has not been caused to be impounded, nor revoked, nor any travel document otherwise is concerned. Subsection 3 will not apply our case. I had a valid passport which was directed to be renewed. If they want to come under 10(3), they have to pass an order under 10(3). Your passport is revoked. Therefore, not 10(3)(d) reliance upon 10(2)(d). কোথায় 2D?
3.
2 এর কোনো D নেই।
তো বলা যায় না এটা একটু দেখে এটা কি রেফার করা কোথায় চলে আসে?
If the authority is not inclined, he must take recourse to a provision of law. They cannot sit tight and say, yes, I shall not pass any order, but I shall not give your passport either.
Notification, sir. Government notification. So 1 year এর কথা বলা আছে যে conviction criminal cases are pending before the court of law. এই ধরনের ম্যাটার গুলোকে রিল্যাক্স করার জন্য এখানে বলেনি যে পাসপোর্ট পার্টি অথরিটিকে পার্টি করতে হবে।
পাসপোর্ট অথরিটিকে পার্টি করার কথা
বলেনি দিস ইজ যে ক্রিমিনাল কেস থাকলে কোর্ট থেকে পারমিশন নিতে হবে।
under the notification of the government. Requirement is only to take a no objection to the court concern. The notification nowhere says that passport authority has to be the party in a criminal proceeding.
Every renewal is equivalent to a fresh grant.
Renewal, then not renewal and fresh grant. These two expressions.
No, under which provision you apply for renewal? Section 7 deals with the duration of passport and travel documents.
Yes.
So this gives power that even if you apply for 15 years or 10 years or 12 years, the authority is entitled to restrict the period. Which is the relevant rule which speaks about renewal?
Yes.
renewal.
Kindly come to
renewal of the এটা EAP 2.
your lordship got the Passport Act, passport rules. There's a form.
EAP 2 form. দর্শক এখানে এটাকে রিলাই করে বলছে যেহেতু ক্রিমিনাল কেসের কথা বলা নেই তাই দেবো না। Paragraph.
Kindly see. It speaks of a form.
EAP2 instruction for denying. আপনি এটা নেন, আপনি এটা নেন, এই বইটা বার কর। renewal, আপনি এটা নেন, ওটা বার করে দিচ্ছি। এই বই বার করেছি, সেটাই আছে।
But it says the form, statutory form. The form is to be used for the miscellaneous service of ordinary Indian passport for renewal.
Where, which form number?
This is form
EAP2.
EAP2. But may I hand over Passport Act?
We've got the Passport Act.
Yes.
You're just seeing the form EAP.
renewal টা কোথায় আছে? renewal. এই যে renewal.
Yes, EAP2.
And see.
No, this says application for issue of a diplomatic or official.
No, EAP2.
EAP2.
Yes, not for, kindly see.
In this book it is said. Oh, no, sorry. EAP2 has been omitted with effect from 1/11/1985.
EAP2 has been omitted.
In this book it is there.
Lord, I can show to your lordship.
2024 বই কোথায় লিখেছে?
Of 2024 publication.
This is with regard to diplomatic or official purposes. Has been omitted.
64 of this book of 2024.
এটা লিখেছে কি করে fill up করতে হবে? Instruction for filling up the two form.
See, what has happened is,
yes,
with effect from 1/11/1985,
yes,
they have omitted EAP2. This EAP2 and EAP3 are all under Rule 5. Rule 5 says, 5(1), an application for issue of a passport or travel document or for the renewal thereof.
Yes.
So issuance and renewal have been treated on par. And if issuance and renewal are treated on par, then the embargo under section 10, subsection 3, clause D will apply.
Lord, kindly see, as your lordship was kind enough to point out, it says Rule 5, issuance or renewal. So these are two different things.
That distinction has been done away with. That form has been removed.
Lord,
Sir, petitioner could have come with a simple prayer saying that please direct the passport authority to pass an order. Instead, they took an order on merits. So therefore, we have to hear out the matter appeal finally.
Lord, kindly do it at any convenient date for your lordships.
Rule 2 তো বলছে reissued fees দিচ্ছে।
Lord, if my lords kindly see once in the list section 6, subsection 2F. That apart, section 10, 3D, section 6, subsection 2F. He is not entitled to passport if criminal case is pending, number 1. This provision has been modified in exercise of the power under section 22 of the Act. And a notification has been issued. There are 2 guidelines in the notification. He has to obtain no objection from the concerned criminal court, and he has to give a declaration that he shall be present as and when the trial shall commence. So the no objection has been obtained from the NIA court. It is his statement in para 6 of the writ petition.
Yes.
He has not obtained any no objection from the other court.
Which
He is relying solely on the Delhi High Court order.
no. NIA court order I have placed before your lordship.
Yes, that is grant of bail only.
No, kindly see. Kindly see the NIA court's order.
প্যারাগ্রাফ 6 তো কিছু বলা আছে যে অর্ডার দিয়েছে
Para 6 of the office writ petition.
6 তো
Page 36, NIA court's order. Page 36, NIA court's order. Second paragraph, considering the above facts and circumstances, passport of the petitioner bearing such and such is directed to be handed over to the petitioner for limited purpose of renewal on furnishing indemnity bond with two sureties, each of like amount, with a condition that one of these sureties shall be resident of Ranchi, Jharkhand. Petitioner is also directed to remain physically present for framing charge on 31 July 2023 and himself receive the passport and will file undertaking that he will not obtain visa or travel outside India after renewal of passport without permission of this court. And he will deposit the same to this court office immediately after renewal. So, what I
In effect, you want this order to be executed by filing a writ petition.
not this order. Kindly come to the Delhi High Court's order. Kindly see.
Delhi High Court's order is not binding on the regional passport authority.
Look, this has not been anybody's case.
কেন আমাকে দিল্লি হাইকোর্টে যেতে হয়েছে সেটা হচ্ছে এটা
They come to page 39. Rather, page 38, there's a 2019 notification, office memorandum issued by the Ministry of External Affairs. The persons against whom criminal cases are pending before courts of India are required to take no objection or permission from the concerned court for renewal or issuance of passport. Hence, the present application is filed, seeking no objection of this court for renewal of the passport of the applicant for a period of 10 years.
due to this notification আমাকে চাইতে হবে
This notification makes it incumbent upon me to take a no objection from the concerned court.
যেখানে যেখানে ক্রিমিনাল কেস আছে
In the present case also, paragraph 7, bottom of page 38, it is noted in the order suspending sentence of the applicant that the applicant shall not leave the country without the permission of the court. Therefore, in my opinion, there is no basis for not renewing passport of the applicant for a regular period of 10 years. Accordingly, the applicant is granted no objection to permission or renewal of his passport for a period of 10 years.
কেন আমাকে দুটো কোর্টে যেতে হয়েছে দিস ইজ ডিউ টু দিস নোটিফিকেশন যেখানে যেখানে ক্রিমিনাল কেস আছে সেখানে সেখানে আমাকে অ্যাপ্লিকেশন করতে হবে
No, allegations are very serious, sir. Charge is very serious.
Look,
Charge in the criminal case which is pending before NIA court is very serious.
But I-
98 witnesses have been examined so
Then
far.
may I say this? May I say this?
No, no.
No, kindly.
You approach the special court saying that, sir, you gave this direction is not being implemented. You issue further directions.
My lord, kindly have a look at the 2019 notification of the central government. Anomaly করে
না এটা হচ্ছে যে
Oh, another.
আছে এটা হচ্ছে এই কারণে আমাকে সব জায়গায় অ্যাপ্লাই করতে হবে
Kindly see
আমাকে একটা কপি দেবে ভাই
তোমাদের notification.
স্যার এইটাই
এক সেকেন্ড দেখে দিয়ে দিই
না না
In exercise of powers conferred by clause A of section 22 of the passport and in supersession of the notification of the government of India dated 14th April 76, the central government being of the opinion that it is necessary in public interest to do so, hereby exempts citizens of India against whom proceedings in respect of an offence alleged to have been committed by them are pending before a criminal court in India and who produce orders from the court concerned permitting them to depart from India from the operation of the provisions of clause A of subsection 2 of section 2. The passport be issued on the following conditions. The passport be issued every such citizen should be issued for the period specified in the order of the court referred to above. If the court specifies a period for which the passport has to be issued, or if no period either for the issue of the passport or for the travel abroad is specified in such order, the passport shall be issued for a period of 1 year. If such order gives permission to travel abroad for a period less than 1 year, but does not specify the period validity of the passport shall be issued for 1 year. If such order gives permission to travel abroad, kindly see this notification nowhere says that paragraph 5. In view of the above, the following instructions may be adopted while processing the passport applications in respect of those applicants who may have criminal proceedings pending before a criminal court.
Because even para 3 of the notification.
Yes, Lord.
Refusal can be on the grounds mentioned in 6.2, section 6.2. 6.2 clearly is attracted, not 1. 6.2 D, F is attracted.
New passport.
Lord, kindly see, shall refuse to issue a passport, not to renew.
No. That's not the way you have to read it. Refusal of passport means earlier there was a separate form for renewal that has been done away with. Even otherwise, the legal principle is every renewal is akin to a fresh grant. In mining matters, in all other matters, every renewal is akin to a fresh grant.
Lord,
therefore, there is no vested right of renewal.
So, Lord, if that troubles your Lordship, Lord, kindly hear it some other day, next Wednesday as my learned trade.
Because this act itself is for the purpose of regulating the departure of Indians from India, of citizens of India and other matters connected therewith. So therefore, there is no absolute right for a person to say that I'll be entitled to.
Lord.
Moreover, sir, there are two cases. One case, there is a conviction. There is a suspension of sentence. So that is one embargo. Second is the matter before the NIA court is still pending. No doubt the court has issued certain directions. Non-implementation of the directions, where to go, how to go, the writ court cannot be an executing court.
Lord, in that event, if your Lordship feels, instructions,
no.
Well, I shall take instructions, Lord. But otherwise, kindly take it next week, as my learned friend also prayed. What I submit is, I shall try to the best of my ability, which is very limited, to satisfy your Lordship, as to what is the consequence of the issue of expression, issue and renewal in the context of this, and whether that EPF form still continues to operate on both the schools.
We have heard the learned, we'll adjourn it. Senior advocate appearing for the appellant and the learned additional solicitor general for the respondent. Prime facie, we are of the view that the order and direction issue, order passed by the learned civil bench, would not call for interference. This prime facie is on account of the fact that the writ court cannot be converted into an executing court to execute an order passed by a special judge, NIA, in Ranchi, Jharkhand state. Secondly, the High Court of Delhi, while entertaining a criminal appeal against an order of conviction, had only suspended the sentence imposed on the appellant writ petitioner, but has not stayed the conviction. Apart from that, we find that passport can be refused on any of the grounds mentioned in section 6 within bracket 2 of the Passports Act 1967. It also appears that the distinction between an application for renewal and an application for grant of passport has been removed after the form for renewal in form E, capital A within bracket capital P -2 was omitted by GSR 860 within bracket E, comma, dated 1/11/1985 with a within bracket with effect from 1/11/1985. This on account of such form being deleted, comma, all conditions which are required to be complied with by an applicant for grant of a fresh passport would equally apply, would mutatis mutandis apply to a application for renewal or extension of the passport. Apart from that, we find that if the apart we find from section 6 within bracket 2 within bracket small f, the passport can be denied, it can be refused on the ground that proceedings in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India. No doubt there are certain notification office memorandum issued by the Ministry of External Affairs, Government of India, as to what is the procedure to be adopted when criminal cases are pending. However, the statutory provision is clear that however, in terms of section 6 within bracket 2 within bracket small f, there is an embargo for issuance of passport when a offense has been committed by the applicant and pending before a criminal court in India. In the instant case, one case is pending before the special court at Ranchi, and in the other case, the appellant has suffered a conviction. Therefore, prima facie, we are of the view that the order and direction issued, the order passed by the learned single bench would not call for interference. The learned senior advocate appearing for the appellant requests time to make submissions on the other on the above prima facie view, which has been recorded above by this court. Adjourned. You give a date, sir. Sometime in March.
Hey, next Wednesday.
No, next Friday.
No. We'll give sufficient time to senior to work on. Next.
Lord, if you sometime next week, otherwise not.
Charge is very serious.
Lord, I tell your lordship has seen the act, your lordship has seen the notifications. Seriousness of charge has never been made.
Security of the country is important.
The charge about this person is not relating to security of the country.
All right, prima facie. Yeah. Of course, he has been convicted under 120B, but here this case, which is now pending for special court, is a very, very serious.
Lord, funding, its allegation is we have funded the Nasalite. That's all.
Probably he will be acquitted. Probably he will be acquitted.
He will be acquitted. No doubt about it. The point is.
All right, sir. Next. Come in March. You give a date in March.
March will not. Because if it pleases your lordship
nothing will happen, sir.
To prepone that.
Lord, may I take by my books?
Sir.
Lordship,
Next.
I appear for the appellant. Lordship, in this matter, Lordship, the writ petition was preferred by the writ petitioner inter alia challenging a complaint dated 18/6/2021, by virtue of which, my lord, CBI, being an independent agency, my lord, has registered an FIR in the year of 2023. My lord, they have challenged the complaint after the FIR was lodged. Now, my lord, by virtue of the impugned order, the complaint has been set aside. So, my lord, the FIR is not getting any force. My lord, in that writ petition, the CBI was not made a party. And my lord, the Punjab National Bank have acted as the consortium leader. Well, all other consortium banks also, my lord, those were not heard, your lordship. What was the finding of the CBI, my lord? We do not know. Well, once a complaint is culminated into an FIR, the complaint loses its force. Now, my lord, it is upon the CBI to say that what ingredients they have found, that they have
But CBI is not a party to
Lordship, CBI was not a party in the writ petition only.
Subject to correction, my lord, I'm appearing with my learned friend for CBI. We have filed 2 applications for intervening. If your lordships direct us, we can serve all the parties and your lordship can hurt, thereby fixing a deadline. Already we have filed.
Lordship, in the meantime, may that impugned order be stayed, Your Lordship, because the CBI has to be heard, Your Lordship.
The order, my lord, it specifically says, my lord, that for my lord arresting the criminal proceedings, my lord, we'll have to, my lord, seek, my lord, a relief in accordance
But
with.
what survives, sir?
Lordship.
If the complaint goes, nothing survives.
No, because my lord, this, my lord, complaint, my lord, was filed in 2021. My lord, the CBI, my lord, filed, my lord, the registered an FIR, my lord, in, my lord, 2023. After 2 years, my lord, in the meantime, on merits, my lord, I have succeeded, my lord, on, my lord, willful default. It's not, my lord, natural justice or, my lord, because I wasn't heard or something. On merits, my lord, I have succeeded. I have, my lord, also succeeded, my lord, before, my lord, the adjudicating authority, National Company Law Board, Company Law Tribunal, my lord, where, my lord, there were, my lord, an applications made, my lord, for preferential payments, my lord, under Section 16, my lord, the old Companies Act, my lord, preferential payments and, my lord, fraudulent payments. My lord, there also, my lord, I succeeded. Matter was carried up, my lord, to the appellate authority, and there also I succeeded. My lord, this is the position. My lord, it's not, my lord, that, my lord, and my lord, the complaint was based on that. That complaint, my lord, there's a reporting provision. My lord, they ought to have reported, my lord, these facts. My lord, if, my lord, CBI has done its own inquiry, I don't know what their application is, and, my lord, they proceed with the FIR, my lord, there's no problem. My lord, so far, what fell from my lord, Mr. Mukherjee, the learned senior advocate, my lord, here when the writ petition was taken up before the honorable single judge, my lord, CBI was not made a party. So CBI has no, my lord, opportunity to, my lord, place the case before the honorable single judge. And here the involvement is, my lord, more than 11,000 crores.
My lord, and there was a specific recording in the order itself that the respondent bank, my lord, has prayed this that the CBI be heard in that writ petition. In spite of that, yes, your lordship, if lordship may kindly seize the order.
Whenever CBI, my lord, get the information from the bank, immediately we file this intervening application. So my endeavor before your lordship will be, my lord, if your lordship kindly fix a date, let us serve the copy to all the parties, and your lordship kindly hear the matter on merit.
But then, if the bank lodged a complaint with CBI.
Gotcha.
All right, they took 2 years and a case has been registered. The complaint does not any longer survive in the form of a complaint. It has matured into a first information.
Yes, your lordship.
My lord, if that is the view, the criminal proceedings will go on. Because I have, my lord, the court has not stayed the criminal proceedings.
No, but then the court has quashed the complaint.
Yes, your lordship.
On the date when it quashed the complaint was no longer a complaint. It became a first information report, or it might have even become matured into.
Complaint, my lord, is only information which has been provided.
So that information on prima facie investigation, the investigating agency thought fit to register a first information report.
Yes.
On alleged ground, on certain.
And, my lord, on the basis of the complaint, it might have done other preliminary inquiries, my lord. And, my lord, lodged, my lord, the
But
complaint.
on the date when the petition was filed, FIR has already been registered.
Yes, your
Yes.
lordship.
Yes.
So in effect, complaint, that is why you call, thereafter the status of the complainant becomes de facto complaint.
Yes.
So that is how the status changes. So that document, whatever they have written to them, is no longer,
Not
in
carrying any
existence.
force.
It has matured into an FIR, whereby the investigating agency has become the complainant now.
Yes, absolutely.
This officer will get into the box and he
My
will
lord.
depose. Probably the complainant bank may be examined as a prosecution witness because he is the de facto complainant.
I'm out on.
So this will have a far-reaching consequences.
My lord, your lordship decides it because, my lord, under, my lord, the circulars. My lord,
No, on merits you may have a good case.
yes, my lord, I want to.
But then to quash a complaint after the complaint has been registered as an FIR,
Quashing of
without the
FIR.
investigating agency or the prosecuting agency being made a party, will set a very wrong precedent.
Yes, sir.
Will set a very wrong precedent. Now, courts have held under what circumstances 226 can be invoked to quash a complaint. Very recently, Supreme Court said, yes, it is maintainable.
My lord,
And my lord, what
my lord, recent view, my lord, your lordship, my lord, earlier, my lord, one view was, my lord, in Article 226, one did not get into, my lord, quashing of complaints. Then, my lord, came one aberration, my lord, from the Supreme Court. But now, my lord, finally, my lord, it has, my lord, considered.
We are yet to go through the judgment, but we have held that it is not maintainable.
Yes.
That is why a
Yes,
specific
my lord.
provision.
Correct, my lord, but that judgment, my lord, the recent judgment of the Supreme
Then what
Court has come
happens is,
later.
sir, this will be laying down a proposition as if a writ petition is maintainable to quash a complaint, despite the fact the complaint has already been investigated upon, and the investigation agency prima facie found offenses have become committed, and a first information report has been registered in terms of the provisions of the CRPC.
Yes.
So, in effect, the 482 court has to quash the FIR.
I bow down, your lordship.
And so far, what fell from your lordship, I bow down to your lordship. My lord, the honorable single judge has passed the order, subject to correction from your lordship, on the basis of the judgment of the honorable Supreme Court of Rajesh Agarwal. That is based on a civil complaint. There are the differences are there, a civil complaint and a criminal complaint. So far, criminal complaint is concerned and FIR is concerned, no question of opportunity of being heard is necessary. So that was not taken account in this order. That will be our endeavor before your lordship.
My lord, the writ petitioner has also approached the Delhi High Court, my lord, because the Delhi High Court was taking a matter so far as the direction of frauds are concerned. My lord, the Delhi High Court also passed an order, but my lord, the Delhi High Court also said that the FIR or any criminal proceeding, if at all initiated, my lord, will remain untouched.
My lord, that is, my lord, the fraud circular. My lord, I am on
Lordship.
willful default. This complaint, my lord, was on the
All
basis
right.
of willful
Which is the application filed by CBI?
Lordship, we have not received.
Yeah, what is the CAN number? Sir?
My lord, CAN number 3. Thou likhe dao, tumi
GA number 3 of 2025. Last day we have.
You serve copies.
Yes, I will serve to my lord both the appellant and also to the advocate on record of the learned senior advocate, my lord, appearing for the respondent. लूटो तो लिखे देना लिखे दे तो लिखे देना
But first we need to decide on the maintainability of the writ petitions.
Yes.
Otherwise, assuming on merits you may succeed, but this will be setting a wrong precedent there. Because in law, the complaint does not exist in the form of a complaint any longer. So we are trying to quash something which does not have a legal existence on the date when the writ petition was filed. And a different person has now become the prosecuting agency. See, assuming he makes a complaint, 1, 2, 3, 4 allegations. During the course of investigation, the investigating agency may find out something else. So they may go beyond the scope of the complaint as well, register other. In fact, the previous case, it has happened like that. The complaint was regarding extortion, etc. Ultimately, during investigation, they found that the writ petitioner was funding extremist organization and banned organizations only for the purpose of advancement of his coal business. So therefore, the matter became was transferred to the National Investigating Agency, and NIA has filed a charge sheet. Almost about 98 witnesses they have examined. Because this is called cover money. That
Yes,
the senior knows better. Coal blocks are all.
My lord, on maintainability, I'm willing to argue, my lord, before your lordships, my lord.
So let it remain stayed for 1 or 2 weeks.
My lord,
Then we
my
will,
lord, may I say this?
in the meantime, we will hear out this application.
My lord.
Whether they have to be, you may have to file your affidavit
Yes.
in opposition. We'll frame the issue. Why
Kindly
2
give me-
appeals?
Two appeals, Your Lordship. One was the parent order. My lord, thereafter, the second writ petitioner came, my lord, for the relief was given to the father, then, my lord, the son came. My lord, that is why there are two orders. And, my lord, we have challenged the parent order, which is appearing as item number 15, and item number 14 is, my lord, the later order, where the son has got the relief, my lord, the same relief.
Oh, same direction.
Same. Yes.
These 2 appeals, we have heard, so record all them. You record also so for intervene for CBI. 2 appeals have been preferred by the Punjab National Bank against 2 separate orders passed by the learned single bench, whereby the learned single bench has quashed the complaint lodged by the Punjab National Bank with the CBI, alleging fraud against the writ petitioners. The learned single bench, while
Alleging diversion of funds.
alleging diversion of funds, the learned single bench, while allowing the writ petitions, had quashed the complaint lodged by the bank to the CBI, but did not interfere with the FIR which has been registered by CBI against the writ petitioners, and left it open to the writ petitioners to seek to approach the appropriate forum seeking quashing of the FIR. The legal question, in our prime facie view, the legal question which is required to be decided at the threshold is with regard to the maintainability of the writ petition. Admittedly, on the date when the writ petition was filed, the complaint lodged by the appellant bank to CBI did not exist in such form, since the complaint was investigated and FIR has been registered by CBI, which has become the prosecuting agency. Therefore, the question would be whether the complaint, which legally does not exist in such a form, would have been interfered in a writ petition after an FIR has been registered by the investigating agency. This issue needs to be decided, as otherwise they needs to be decided in these appeals. Learned senior advocate appearing for the respondent writ petitioners has submitted that the writ petitioners were successful in the proceedings which were initiated under the Companies Act, as well as before the Delhi High Court in other collateral proceedings, and they have got an excellent case on merits. The merits of the case relating to, with regard to the merits of the matter, the same can be gone into after this court decides on the maintainability of the writ petition. Further, in our prime facie view, the writ petition was defective in not impleading CBI as a party, since CBI should be considered to be a proper and necessary party because they have acted on the complaint lodged by the appellant bank and investigated the matter and registered a case against the respondents, against the respondent writ petitioners. This aspect also has to be gone into. CBI has filed 2 applications to add them as parties in the appeal proceedings, since they were not implemented as respondents in the writ petition. Let copies of the said application be served on the learned advocate appearing for the appellant bank, as well as the learned advocate appearing for the respondent writ petitioner, with liberty to file affidavit in opposition if they so desire. You can please support the appeal. Next time. But has CBI filed an independent appeal?
No, Your
Third party appeal?
My lord, we have already filed, my lord, intervening applications.
By way of intervention application, if you are if you are allowed to be pleaded,
Yes,
how can you challenge the order as the respondent?
You can only support the case of the appellant.
yes,
See, as an investigating agency, this proposition which has been laid down, you should be more concerned with that.
yes, that's true, that's true. My lord, I will take instructions on that
No,
part,
you
but in the
discuss on
meantime, let this,
Now you
yes,
serve
yes.
full stop. In the light of the above prime facie view, we are inclined to entertain this appeal. And as the order and direction issued may have other consequences, the impugned order shall remain stayed till the next hearing date. List the matter. Today we are on 7th.
Lordship.
21st.
Around 21st, I think, February.
Grateful to your lordship.
My lord, in the meantime, your lordship has been pleased to give them to file affidavits. My
Due text.
lord, both the matters, my lord.
Item number 16.
Lordship, in item number. Lordship, in item number 16 and 17, I'm saying for not to be.
Therefore, the respondent, my lord.
Lordship, in this matter, I'm laid by Mr. Pratyush Jhunjhunwala. He's out of.
No, he's not there. You start.
No, it's our appeal, my
Someday you
lord.
have to
It's
start.
our application. It's our application. It's a departmental application, but he requested me that they will be praying time.
All right.
The matter to
Grateful to your lordship.
It's 16 and 17.
16 and 17.
Item number 18.
Your lordship appear for the RP, your lordship.
Well, we similar to addition under section 68 of the Income Tax Act.
Your lordship, before my learned friend starts, I have a preliminary objection that the company's the IRP has been appointed, your lordship, and was secured under section 14. So I do not think my learned friend's claim is maintainable.
What is the stage of the proceedings before?
The RP proceeding has failed, your lordship, and we have filed the liquidation application.
That is
It's
going to be
pending.
the knowledge of the assessing officer. That is not in our knowledge. But your lordship, kindly, my lord, come to the page 15 of the assessment order. Surprisingly, in 1 and 2 days, there is a huge cash transaction. Page 15. But 15/1/2009, cash transaction 9 lakhs. 15/1/2009 cash transaction 6 lakhs and odd. 15/1/2009 cash.
This is not huge transaction.
But
if there are 2 more zeros, then it is huge transaction. But the tribunal says the learned assessing officer has nowhere doubted about the genuineness of the investments appearing in the books of the assessee as on opening 1/4/2008. Once the investment in the previous year has not been doubted, and out of such investment, the alleged sum has been received on account of sale of part of the investment, how 68 can be invoked?
May I submit one thing, my lord?
Sir, 8/9, this investment was made. It was accepted by the AO. Out of that investment, they have liquidated some investment in the assessment year under consideration, 9/10. How it can be doubted is what they say.
But the tribunal, your lordship, kindly see tribunal's order, that is page 33. Only paragraph number 4, tribunal held that there is no reasoning. May I I'm gonna read out the paragraph number 4. On perusal of submission filed by the assessee before the lower authorities, we find that alleged sum received by the assessee was on account of sale of investment on which was appearing in the balance sheet. This is not sale of investment. This is a sale of share. The assessing officer was nowhere doubted about the genuineness of investment appearing of the books of the assessee on opening of such and such date. Once the investment of the assessee is made in the previous year has not been doubted on such the investment, the alleged sum of rupees is such and such shall part of their investment. In our considered view, the provision of section 68 cannot be ignored. We also notice the claim of the assessee duly supported by the copy of the bank statement, and namely DCB Bank, ING Vaishya Bank, filed by the assessing officer, and the consideration was received. Here, the assessee, after filing of the appeal before the CIT appeals, he has not cooperated, he has not appeared also before the CIT appeals. Now, there is a judgment.
No, they didn't appear before the tribunal also.
Yes. And now, not only filing the bank statement, that does not say that the transaction is genuine. May I place two judgments on this regard, Millard. Yeah. Okay. 2014, the taxman from 110. Copy the. Lordship, kindly see paragraph number 14, Millard. 13, 14, 15. May I read out?
Have you got the grounds of appeal which were filed before the tribunal?
Lordship,
The memorandum of appeal which was filed before the tribunal.
Lordship, that is not with us, Your Lordship. I appear for the RPO, Lordship, and this company was admitted by an order dated 25th May 2022.
That is not
And,
in our knowledge, but they
Your-
have not
Your
informed the
Lordship,
assessing officer
thereafter-
also.
Your Lordship, thereafter, by an order dated 14th November 2024, the RP has been changed and I am appointed.
Now you are the RP.
And Your Lordship, this admission, the RP was appointed back in 2022, and my learned friend's application is 2020 in 2024. So thereafter, any claim that my learned
should
friend
be the
has
knowledge
to
of
be
the
before
that
the
should be
COC,
the
Your
knowledge
Lordship.
of the assessing officer, and
was
that
there.
knowledge of the department.
Public notice was given, Your Lordship.
That is why Supreme Court says you can't proceed. We followed.
There are plethora of judgments in this regard, Your Lordship. Once RP is appointed,
No,
there
we
is
have
no
followed
claims.
that decision. No? Where is that decision? Are you carrying any of the decision?
Judgments, I'm not carrying, Your Lordship, today. Your Lordship would give us one other day. I'll just come back with the judgments, Your Lordship. Your Lordship keeps it any day next week. I shall come back with the judgments, Your Lordship.
Because you can't prosecute
yes.
this appeal. In fact, Madam Smita Das, they appeared in one matter. Several matters we have.
Stated lawyer. I shall come back
That
next
should be
week.
the knowledge of the department. Whether I don't know where public notice is
Public
given or
notice
not
is
given.
sufficient. All right. We have heard Mr. Sonsa, an advocate for the appellant. The respondent is represented by the insolvency resolution professional who has been appointed by the National Company Law Tribunal, Kolkata bench. The learned advocate request time to get necessary instructions and make submission. List it next Friday, next Wednesday. Next Wednesday.
Wednesday. Grateful, Your Lordship.
It is better next Friday. I have to take instruction Friday.
You do one thing, not next Friday. Instead, you push it on 19th.
19th. Grateful.
রাতে তো ইনস্ট্রাকশন নিতে হবে, এগুলো সব রাখো ঠিক করে।
Matter number 19.
My lord, on the last occasion, my lord, your lordship, my lord, directed me, my lord, to file the paper book that was filed before the learned tribunal.
You give them copy.
আরেকটা লাগবে?
Thank you.
You go through these documents better because they'll rely upon it. In terms of the liberty granted, okay, a compilation containing all documents which were filed before the learned tribunal has been filed, which is taken on record, copy of which has been served on the learned advocate for the appellant. List the matter. 19.
Great.
Matter number 20.
May it please your lordship. Yes.
My lord, in this matter, my lord, there are two issues, my lord. One factual and one legal. My lord, there was considerable delay in filing the appeal before the tribunal. At the time of filing the appeal, your lordship will kindly find at page 45 to 47, we had filed an affidavit in support of the condonation of delay. My lord, thereafter, my lord, the matter came up before the tribunal. The tribunal's order is at page 48 to 51 of your lordship's brief. My lord, the tribunal extracted a portion of the reasons given for the delay, which was given by way of an affidavit. Now, my lord, at paragraph, if your lordship kindly now comes to page 50, my lord. First, my lord, page 6, page 49, and then page 50. My lord, at page 49, your lordship will very kindly find that the affidavit which is filed in support of the delay, only a part of the delay has been set out, and therefore the tribunal observes that although we had not pleaded COVID, but the tribunal observes that COVID has finished in the year 2021, which is quite incorrect on facts. Now, my lord, thereafter, for testing the supposed conduct of the appellant SSC, your lordship will kindly come to page 50. The tribunal sets out the paragraph of a portion of the paragraph of the order of the CIT appeal. Now I come to the legal issue. My lord, the CIT appeal passed the order for non-prosecution. Now I am covered by your lordship's judgment as well as section 250 and 251 that appeal filed cannot be dismissed for non-prosecution. My lord, I'll straightway come to that, my lord. If your lordship very kindly come to page 6, page 6, paragraph 12 and 13. Your lordship kindly finds there were two appeals in that matter before the Honorable High Court. One of the appeals was by the SSC. Now, in that context, your lordship has been very pleased to hold, if I may place paragraph 12 and 13 for your lordship's kind consideration. One of the grounds canvassed before the tribunal was that the Commissioner of Income Tax Appeals has disposed of the appeal for want of prosecution, and therefore it is submitted that there has been violation of principles of natural justice. These issues are required to be considered by the tribunal, and having not been considered, we are inclined to interfere with the order passed by the tribunal. For the above reasons,
but then the appeal was time barred by 1,288 days.
I'm extremely grateful, my lord. In that context also, my lord. In that context also, my lord, if your lordship kindly finds there was genuine difficulty, there is a family company. If your lordship kindly peruses the affidavit filed in support of the condonation, my lord, for once, my lord.
Please give.
Page 45 to 47, your lordship's brief. The relevant portion is at page 47, my lord. Well, definitely I find there's a delay. I cannot improve upon that. But in support of the delay, my lord, the appellant SSC had filed an affidavit. A part of it was reproduced in the order of the learned tribunal. And thereafter, my lord, the learned tribunal has extracted the first 3 paragraphs of the affidavit. And thereafter, my lord, there was some unsurmountable difficulty, my lord. Otherwise, my lord, your lordship, definitely the SSC suffering an order of the CIT appeals will definitely not delay, my lord. And in that context also, my lord, if I may just rely on judgment of your lordships, my lord. My lord, in that matter, my lord, there was a more delay, my lord, 1637 days, my lord. In that context also, your lordship has been pleased to condone the delay after laying down the propositions, my lord, at page 3, paragraph 7, my lord.
No, my lord, this is, if I, my lord, could only indicate that this is, my lord, most frequent affairs for us, my lord, to come up before lordship and not to pray for condemnation. But someone need to, my lord, appear. Here, my lord, this is the first time.
But
It is,
that
my
is
lord,
why, my lord, that is why I said
my learned friend is appearing, but
factual and legal issue.
I understand, but my lord, the issue involved, the impugned order is, my lord, only on the point of delay, and my lord, it can be shown, my lord, from the record itself that my learned friend.
Then the CIT appeals should have decided the matter on merits.
No, my lord, my learned friend even didn't appear before the CIT appeal. My lord, someone need to, my lord, appear to praise the issues.
In that, lordship will kindly permit only. I will not.
Kindly see, my lord, page 37 of your lordship's brief. My lord, CIT appeal, my lord, has gone on to, my lord.
Kindly comes to page 3, paragraph 8. Lordship will kindly find page 3, paragraph 8. 6 lines from that paragraph bottom. Each line sentence starts with therefore. Has your lordship's got it? Therefore, just as it is not open to the assessing officer to not complete the assessment by allowing the assessee to withdraw its return of income, it is not open to the assessee in appeal to withdraw and or the CIT appeal to dismiss the appeal on account of non-prosecution of the appeal by the assessee. This is amply clear from section 251(1)(a) and (b), an explanation to section 251(2) of the Act, which requires the CIT appeal to apply his mind to all the issues which arise from the impugned order before him, whether or not the same has been raised by the appellant before him. Accordingly, the law does not empower the CIT appeal to dismiss the appeal for non-prosecution, as is evident from the provisions of the Act.
Now, my lord, the tribunal, my lord, would have
That is
dealt
my
with-
humble submission, my lord.
Now, my lord, tribunal, my lord, would have, my lord, dealt with this issue had that been, my lord, raised before the tribunal had my lord, would have
My
appeared
lord,
before
the tribunal in its own
tribunal, my lord, by the
my lord,
impugned
the
order.
tribunal in its own endeavor to find out the conduct of the appellant has gone into the order of the CIT appeal. Once it has gone into the order of the CIT appeal, the tribunal should have noticed that the order has been passed by the CIT appeal for non-prosecution.
But tribunal, my lord, subject to correction, could not have, my lord, gone in to see that portion until unless, my lord, delay has been controlled.
But the tribunal has,
Delay was not, my lord,
your
paid to
lordship
be
kindly
controlled.
says the tribunal has gone into that. To see my conduct at page 50, 51, your lordship will kindly find a paragraph 7. The tribunal has extracted a portion of the order of the CIT appeal. But when the law does not empower the CIT appeal to dismiss my appeal for non-prosecution, had the tribunal not gone into that aspect, Lord, I would have no chance to make this submission with your lordship. At page 51, the tribunal, to see the apparent conduct of the appellant, has extracted the order of the CIT appeal. Lord, having done so, Lord, in my very humble submission, the tribunal ought to have noticed that the appeal was dismissed for non-prosecution, confirming the demand. Lord, I have submitted with your lordships one division bench judgment of your lordships and the Bombay High Court, Lord, Honorable Bombay High Court.
But in your grounds of appeal, you did not raise this issue.
Yes.
Lord,
Yes.
but Lord, your lordship, Lord, just now I'm not carrying judgment.
Now nobody did anybody appear before the tribunal?
Lord,
No.
Lord, lordship,
That's what, my lord, I was indicating your lordship that this is the first time my learned friend is appearing before any forum.
But
not even before CIT appeal.
But
it was his
lordship
appeal.
kindly sees, my lord.
Not even before the
Had
tribunal.
the tribunal stopped by saying that we are not satisfied with the delay, but tribunal, to see my conduct, having gone into the order of the CIT appeal, have at once should have noticed, my lord. Lordship kindly sees for my satisfaction, my lord, page 50, paragraph 7. The tribunal ought to have stopped at that, but tribunal, lordship kindly, my lord, sees paragraph 7, just before the portion is extracted, 2 lines. We are unable to trace out any reason for the purpose of condoning the delay. Moreover, the order of the CITF also reflects the conduct of the SSC appellate. In that also, my lord, the tribunal has only set out the preamble of the CIT appeals order. The tribunal does not set out the portion where the CIT appeal has dismissed the appeal for non-prosecution.
Tribunal, my lord, had actually, my lord, dealt with the fact that the delay could be condoned or
No,
not.
no, no. Then why the
Ultimate conclusion was, my lord,
no,
the
why
rejection
did
on the ground of
otherwise?
delay.
If that be so, my lord, in my very humble submission, my lord, how the tribunal had gone into the order of the CIT appeal?
That has been, my lord, just reproductions
No,
of
no,
the
no,
same
no.
fact.
It
But
cannot be so, my lord.
ultimately, my lord, the ultimate portion whereby, my lord, the application was rejected was only on the ground of delay.
No.
Because no one has praised that.
But CIT appeal, the CIT appeal at the first instance cannot dismiss the appeal for non-prosecution. The tribunal to test that goes into the order of the CIT appeal, my lord, in my very humble submission. And my lord,
Give the income tax act.
but that the Bombay High Court has also, my lord, summarized the relevant portions under section 250 and 251, my lord, and has also extracted that. Will the Bombay High Court, my lord, for your lordship's, my lord, convenience, has also set out the relevant provisions of the Act at paragraph 7, page 2, and then paragraph at page 3 also, my lord.
In any other case, he may pass such order when it has nothing to powers of the may confirm requirements or assessment. The children in any other case, he may pass. সেটাই বলছে যে গোটা ফেলে কোনো কাজ বন্ধ এখন সিআইটি আপনি মেডিকেল ঢুকে ঠিক আছে এখানে সেটা রিপোর্ট দ্যাট এটা
But there is no power to pass an order dismissing an appeal for non-prosecution.
No, my lord, if you kindly see, my lord, the observations made by the
By
tribunal.
the CIT. By the CIT appeals.
My lord.
If you see section 251. 251.
Yes. Subsection C, my lord. The subsection C of that section is important.
In any other case, he may pass such orders in the appeal as he thinks fit. This C has to be read in conjunction with the other clauses.
And A relevant is my lord,
As
subsection
he
A.
thinks fit. In an appeal against an order imposing a penalty, he may confirm or cancel such an order or vary it so as to either enhance or reduce a penalty. Clause B. Clause A. In an appeal against order of he may confirm, reduce, enhance, or annul the assessment.
Thereafter, explanation 2 to subsection 2 also, my lord, if your lordship kindly can. The Bombay High Court has also considered that, my lord. And your lordship has also considered in the judgment which I've handed up, my lord.
No, that in that one of the grounds raised before the tribunal was that. Therefore, we came to the conclusion that that has to be decided by the tribunal. We'll send it back to the CIT appeals.
My lord.
And
But my lord, someone need to, my lord, I understand, my lord, the legal issues, my lord, that has been raised before, my lord, the tribunal at the time of presenting the
administrative
memo.
expenses, whether it can be deducted, 40 AII.
But my lord, the issue, my lord, which my lord is dealing right now, my lord, is also, my lord, invites your lordship, my lord, to take into note of the fact that in none of the forum, my lord, the SSC has, my lord, taken out any endeavor, my lord, to represent the issue.
We don't.
And the conduct, my lord, that is something, my lord, which tribunal has gone on to record. It is not that, my lord, that recording of that portion which my learned friend is actually, my lord, trying to show to your lordship is, my lord, actually, wherein, my lord, the tribunal had recorded the conduct of the SSC.
COVID didn't come to an end in 2021.
No. Even Supreme Court has also observed. Your Lordship, kindly just give me one moment. The Supreme Court says during the period of COVID, nobody can be said sleeping over their rights. Lordship will kindly give me a moment. Yes.
When they are filed, condonation delay.
No, I am not taking the excuse of COVID. But Supreme Court tribunal says.
No, one of the reasons you have pleaded is COVID.
No.
Reasons.
In the affidavit.
Yes, in the affidavit.
But what tribunal holds, my lord, that COVID is finished in 2021. Only that thing I am.
But my lord, the application was taken out in the 2023.
Page 3, my lord.
So my lord, it's not the entire period is not covered by the COVID period. I can.
In several of your affidavits also.
Yes, I was very candid on that score at the very beginning.
No, Lordship,
but
kindly
I
finds
also
at
indicated, my lord,
10,
we appear and we pay
paragraph
for
10
condonation.
at page 3. When the whole world was in the grip of devastating pandemic, you could never have been said that the parties are sleeping over their rights. My lord, I am not trying to lay down any proposition, but what the tribunal holds, COVID is over in 2021, my lord. Even your lordships in Kalinga, my lord, has passed an order recording the judgment of the Supreme Court.
Yeah, present appeal justification for not appearing before the tribunal.
1 minute. Lordship will kindly give me 1 minute.
There is no justification even offered before the tribunal for non-appearance.
No.
And even my lord, before lordship, if your lordship kindly take note of the fact that the application was taken out before the tribunal in 2023, I would have understood, my lord, the tribunal has, my lord, wrongly recorded regarding the period of the COVID. But during that period, my lord, there is no explanation. And my lord, there was no one to, my lord, raise the grounds before the tribunal.
Page 2, my lord, paragraph 4, wherein Supreme Court till 2022 has passed, extending the time. And my lord, at page 3, paragraph 8, your lordship has taken into consideration the celebrated judgment of the Supreme Court in Katiji, paragraph 8, my lord. And thereafter condone the delay, my lord. Look, the tribunal should have taken a holistic view. How tribunal holds to the contrary that 2021 COVID is over.
There the revenue succeeded. All right, please come. This appeal filed by the SSC under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 29th April 2024 passed by the Income Tax Appellate Tribunal, SMC Bench, Kolkata, within bracket Tribunal, in ITA number 632/KOL/2023 for the assessment year 2011. The assessee has raised the following substantial questions of law for consideration.
Look at page 18, my lord. Para 45.
Page 18.
Question 1 and 3 would have sufficed.
1 and 2.
1 and 3.
We have heard so also. The appellant assessee filed its return of income for the assessment year under consideration, namely 2011-12, on 5/9/2011, showing total income of rupees 4,63,130. The assessment, the return was processed under section 143 within bracket 1 of the Act, and subsequently the case was selected for scrutiny, and notices under section 143 within bracket 2 and under section 142 within bracket 1 were issued. In response to the notice, the assessee appeared his books of accounts, bank statements, and other relevant details and documents. The assessment officer completed the assessment by order dated 30th March 2015. Gave as interest, administrative expenses, expenses under section 14 capital A, and disallow the sundry balance return of. Agreed by the same, the assessee preferred appeal before the Commissioner of Income Tax appeals 1. Assessee did not appeal. Despite several notices issued by the appellate authority. Appellate authority, after noting the grounds raised by the assessee in the memorandum of appeal, on the ground that none appeared for the appellate assessee. Thereafter, the appellant was not diligently for the tribunal, but belatedly filed the appeal and prayed for condemnation of the tribunal by the impugned order on the point of view. Agreed by the same, he asked the sentence. We will elaborate to that the appellant assessee does not diligent in prosecuting or promptly filing each time. Over the question which has arisen for consideration in this case is whether the first appellate authority could have dismissed the appeal on the ground that the appellant did not appear in the proceedings, despite having noted the grounds of appeal as raised by the appellant. The advocate appearing to the appellant placed claims on the decision check 101 versus Income Tax Officer Non-Corporate Lot 70, bracket 2 Chennai, 2021. And the decision in the case of Commissioner of Income Tax Union Bracket Central for Nagpur versus Prem Kumar Arjundas Mishra, bracket Cheers. Tax one document. With regards to appellant should not be considered shown sufficient cause for not proceeding and much of the period was during the pandemic, when there was a lockdown situation. For the appellant, there's millions of financial services. Live law C 847 and the decision in the case of dispute of in CFP 11768 of 2020. 7120. Prosecute the matter. Prosecute the arbitration. Not before the tribunal. Command cannot be heard procedurally that the tribunal ought not to have dismissed the order. Power of the joint commissioner to bracket appeals or the commissioner with bracket. Subsection 1 states, if disposing of an appeal, the commissioner of shall have the following in the bracket small a. This courts 51 country. Small a. Small a, you put dot. Then small b. Subsection 2 of section 251 states that the joint commissioner with the bracket appeals or the commissioner with the bracket appeals as the shall not enhance of an assessment or appellate or reduce the amount of the thus the appellant has had a reasonable opportunity of showing enhancement or reduction. The explanation contained under in section 251 states that in disposing of an appeal, the commissioner appeals may consider matter arising out of the proceedings in which the order appeal notwithstanding that such matter was not released before commissioner appeals by the appellant. Thus, on a plain reading of the above provision indicates that the commissioner appeal should decide the appeal petition on this. It is a submission of the learned senior standing counsel that in terms of section 251 within bracket 1 within brackets 1, commissioner appeals can pass such orders as he thinks fit. Clause C, in our opinion, should be read. Clause A, brackets 1, and clause B. This is so because the power vested with the commissioner within bracket appeals is co-determinant that of the power of the assessing officer. In Prem Kumar Arjun ka Sutta, the High Court of Hong Kong, by considering a similar issue, pointed out that the powers of CID is co-terminus with that of the assessing officer. That is, can do all that the assessing officer could do. Therefore, just as it is not open to the assessing officer to not complete the assessment by allowing the assessee to withdraw its return of income, it is not open to the assessee in appeal to withdraw and / or the CIDA to dismiss the appeal on account of non-prosecution of the appeal by the assessee. In the case of Ratan Chand Manohar Lal, the division bench had interfered with the order passed by the tribunal, since the learned tribunal had not decided one of the grounds which were raised before it, namely that the Commissioner of Income Tax within the application not have disposed of the appeal for one of the grounds which led to setting aside the order passed by the tribunal and the matter being remanded back to the tribunal for fresh consideration. The Honorable Supreme Court in Aditya Kaitan has taken note of the impact of the COVID pandemic and observed that when the whole world was in the grip of devastating command, it could not expect that the parties were sleeping over its rights. In this case, it is no doubt true that the entire period is not covered during the COVID pandemic, but the part of the period was undoubtedly covered during the COVID pandemic. And it is also a fact that even thereafter, there has been some delay in the matter. However, what is to be borne in mind is the petty legal principle that the facts of each case has to be considered before applying the legal principle as to how an appeal is to be decided. Ordinarily, the litigant does not stand to gain by either preferring an appeal belatedly or not appearing before the appellate. There may be cases where, for certain malafide, appellate will avoid the proceedings. However, in the instant case, there is research got to show that the appellant was deliberately not or before the tribunal, or that deliberately they did not appear before the Commissioner of Income Tax for certain other collateral purposes. Therefore, we are, apart from that, since the matter involves the tax liability, tax and appellate remedy of income tax appeals is a very valuable since the commissioner's powers are co-terminus to the CATA for being decided on merits, subject to the condition that the appellant should not disposal of the appeal by the Federal Commission for the above reasons. The appeal is allowed, the order passed by set aside, as well as the order passed by the CATA dated what is the date of order of the CATA appeals?
16th October 2019.
The appeal stands restored to the file of CATA on merits.
I'm grateful.
Head number 21.
Milord, I am for the appellant. Milord, in this matter, Milord, if your lordship kindly sees, Milord, I have two hurdles to cross. Milord, firstly, I lost before the Commissioner Appeals, and secondly, I lost before ITAT. So, Milord, what I want to show your lordship is that the assessment order has not been appreciated by the appellate forums. Milord, kindly take page 12 of the petition. Milord, that is the assessment order starts there. And kindly turn over the page. At page 13, there is a list of companies from which this assessee has unsecured loans amounting to 4 crores 10 lakh rupees. Now, Milord, when the assessing officer, it is contained in the order, when the assessing officer sent the inspector through these companies, except for the signboard, there was nothing. And Milord, the assessing officer, which the tribunal and the appellate authority did not appreciate, is that the assessing officer has seen all the accounts of each and every company. And in one company, which has already been struck off. And that is recorded in the tribunal's order also.
Then why tribunal dismissed your appeal?
The tribunal dismissed the appeal because all monies have been received by me through banking transactions.
That is not the sole criteria.
Milord, that is the sole criteria taken by the tribunal.
No.
Whereas, Milord, the notices were served on the directors, they did not appear. Then inspector went and he only found that in some places there was no board and some places there were boards. And kindly see from page, Milord, page 12 till, Milord, the assessment orders ends at page 98. So, Milord, from page 12 to page 98, the assessing officer has taken, Milord, each and every company and the accounts of filed by these companies. And he has gone on details as to why these companies he has thought to be sham companies. Milord, just for, Milord, they converting the black money to white money. And Milord, your lordship will be, Milord, surprised to note that kindly come to page 126. The tribunal records that this company, one of the companies which has given the loan, has been struck off by AMCA.
Assessment order 87 pages.
87 pages.
All the documents are attached, my lord.
Because all the documents have been considered, all the accounts have been annexed, and everything has been detailed discussed. Milord, which the appellate authority unfortunately did not consider.
My lord, the appellate authority and the appellate tribunal, both the forum have independently gone through the
There are
facts.
3 factors, 68, 3 factors to be. We have also held, there are several decisions which say, merely because the transactions are through banking channel, it cannot be taken as to be a genuine transaction. Creditworthiness also has to be proved. If they say, let us say, for example, one of these companies which has lent monies to the assessee has been struck off during the relevant assessment year or earlier or subsequent. And other companies have been established to have no business income or no income at all or negligible income. Where did they have the funds to lend money to? And there is a finding also to say that no interest was paid by the assessee.
No, my
No
lord,
security, no security.
interest after deducting TDS. Interest was paid after deducting TDS. Honorable tribunal had
And
observed.
unfortunately, sir, it is a 2-page order, CIT appeals.
Yes, my lord. CIT appeal and also the tribunal order is there.
Tribunal order is also very they quoted that Orissa judgment, Supreme Court judgment.
Rohini
that
Builders.
says a
But my lord, they had independently considered all the facts and all the documents submitted by us.
Of course, in certain cases we have held that merely because the directors of the assessee or the directors of the companies which have given loan have not appeared may not be always fatal. If they have responded to the summons, produced their bank statements, produced their assessment orders, etc., then that could have been appreciated by the AO. But certain AOs will go, no, they did not respond to summons. Therefore, I will not look into document. We have interfered. We have dismissed their appeal, or rather allowed assessees appeals also.
My lord, in this
It
regard,
is actually the finding of the appellate authority is only 3 paragraphs. Page 111, para 5.2, 5.3, 5.4. That's all. 5.5, they refer to Rohini Builders, Nimbus India, Shankar Industries. This is wrong, sir. See that AO has done some exercise. At least that exercise should be reviewed by the CIT.
yes, my lord,
Power
but
is coterminous.
all these documents have been produced in front of CIT appeal and the landed
But he should
tribunal.
See, you make submissions. We just say we have heard the learned counsel for the appellant. We're not satisfied with submission dismissed. Will you agree with that judgment?
No, my lord.
Immediately,
But,
Supreme Court will set aside. What is all this?
but my lord, the landed tribunal had considered the rival
We will
contentions
send
also.
it back. Let them examine all documents, re-examine all documents, and then take a decision. This appeal by this revenue filed under Section 260 Cap Clear of the Income Tax Act 1961. Within bracket, the Act is directed against the order dated December 5, 2023, passed by the Income Tax Appellate Tribunal, B Bench, Kolkata, within bracket Tribunal, in ITA number 485/KOL/2023 for the assessment year 2016-17. The revenue has suggested the following substantial questions of law for consideration. Page 7 and 8, question numbers 1, 2, and 3. We have heard so and so. The assessee filed their return of income for the assessment year under consideration, namely 2016-17, on 15/10/2016, declaring a total income of rupees 70,75,050. The return was processed under Section 143 within bracket 1. Thereafter, the case was selected under manual compulsory guidelines of CBDT. Full stop. Pursuant to which, notice under Section 143 within bracket 2 was issued on 8/8/2017, and subsequently notice under Section 140, first is 143(2) and second notice is under 142(1), along with questionnaire, was issued on 2/7/2018. In response to the notices, the authorized representative of the assessee appeared before the assessing officer and filed their submissions and documents. The assessing officer completed the assessment by order dated 21/12/2018. At the outset, we need to point out that the assessment order is a very elaborate order wherein the assessing officer has examined each and every transaction done by the assessee, namely the unsecured loans availed by the assessee from certain entities. After examining the entire facts, the assessing officer has come to a conclusion that that the assessee failed to prove the onus cast upon them under Section 68 of the Act, namely the identity and creditworthiness of the persons from whom monies were taken and the genuineness of the transaction. Consequently, addition was made. The assessee carried the matter on appeal before the Commissioner of Income Tax, before the National Faceless Appeal Center within bracket NFAC, Delhi. The appeal was allowed by order dated 16th March 2023. The order, though appears to be a 15-page order. The conclusion and decision of the appellate authority is confined to only 3 paragraphs, namely paragraphs 5.2, 5.3, and 5.4. The remaining paragraphs are reference to certain decisions of the high courts and extract of section 68, and the appellate authority proceeded to allow the appeal. The revenue carried the matter on appeal to the learned tribunal, which by the impugned order has dismissed the appeal on the ground that the on the ground that the order passed by the learned CIT within bracket A, don't say learned, CITA is a well-reasoned order which has been passed after taking into account all aspects of the matter. Unfortunately, neither the order passed by the CITA nor that of the tribunal is a speaking order. As pointed out earlier, the assessing officer has done an elaborate exercise by examining each and every transaction of the 8 parties from whom the assessee is said to have obtained unsecured loans. The factual exercise done by the assessing officer was not re-examined by the CITA nor by the tribunal. The CITA, being the first appellate authority and his powers conferred under section 251 of the Act, being coterminous to that of the assessing officer, was bound to examine the correctness of the factual findings recorded by the assessing officer. And this exercise has not been done by the CITA. By way of illustration, we can point out that in some of the companies which are said to have extended unsecured loan to the assessee have no existence at all, or no business activities, or negligible surplus income, and one of the companies have also been struck off from the register of companies maintained by the regional director of company affairs, maintained under the provisions of the Companies Act. Therefore, we are of the view that the matter requires to be reheard by considering in detail the correctness of the factual findings recorded by the by the assessing officer. For such reason, we are inclined to interfere with the order passed by the learned tribunal as well as that of the order passed by the NFAC. Accordingly, the appeal is allowed. The impugned order passed by the learned tribunal is set aside, and also the order passed by the NFAC dated 16/3/2023 set aside, and the matter is remanded to the NFAC to consider all the factual issues which were raised and considered by the assessing officer, the documents which were taken note of, and all attendant circumstances, and thereafter pass a speaking order on merits and in accordance with law. Consequently, the appeal is allowed on the above terms, and the appeal is allowed on the above terms, and consequently, the substantial questions of law are left open. Next.
Item number 22.
My lord, this matter I am led by Advocate Abraham Bhushum that he is not in this court due to some personal difficulty. So kindly make it not today.
But can we have it, Lord, after 2 weeks, Lord? Because I would request my friend, Lord, through your lordships, Lord, if we can have the benefit of the paper book filed by them before the department, Lord, that may be required, Lord, before the ITAT.
All right. We have heard so and so, so and so. The learned advocate for the respondent assessee is directed to file a compilation containing all documents which were filed in the form of a paper book before the learned tribunal.
Grateful. Lord, same order in 23 also, Lord, because
23 also same order, and the matter can come on 28th February.
grateful. Grateful.
Item number 24.
May it please, Your Lordship. Last occasion delay was condoned. Now, this is my lord an assessment order that has been made by a reassessment under section 147. And that was my lord taken out on the ground that there was a penny stock company wherein my lord the assessee has invested. Now, my lord, the assessment order, my lord, had elaborately explained all the points. Thereafter, the assessee, my lord, have assailed that order before the tribunal, not on the ground that reopening was bad, but on the merit of the matter. I shall show, my lord, the grounds that has been taken before the tribunal. First of all, my lord, kindly my lord, turn to page number 10 of, my lord, the stay application. Lordship, I got it, page 10 of, my lord, the stay application. Wherein, my lord, the materials on the basis of which, my lord, this reassessment has been initiated, my lord, has been described. And the assessment officer, my lord, has categorically indicated, my lord, the materials, my lord, that has been found. Ultimately, my lord, the assessment order was passed. Now, my lord, if your lordship kindly turn to, my lord, the order of the CIT appeal that starts from page number 28. And if your lordship kindly turn to page 30, wherein, my lord, the CIT appeal, my lord, have reproduced, my lord, the ground taken by the assessee in regard to assailing that order.
Page number?
Page 30 of your lordship's brief. Now, my lord, I do not find any ground taken with regard to, my lord, the challenging the reopening proceeding. This is all with regard to, my lord, the merit of the addition. So, because in fact, after my lord, initiations of 148 proceeding, my lord, he has participated in the assessment procedure, assessment order has been passed. So, my lord, the question of, my lord, going into challenging the reopening proceeding doesn't arise at all. And rightly, that point has not been taken by the assessee before the CIT appeal. Now, my lord, kindly turn to, my lord, the tribunal's order. That appears, my lord, from page number 41 of your lordship's brief. That is internal page number 4 of the impugned order, my lord. Now, my lord, the tribunal have, my lord, gone into examining, my lord, the validity of the reassessment proceeding by quoting a CBDT circular, which, if I, my lord, could respectfully submit, not a law at all. That might act as a guideline to the department. No advantage and no right is created on the basis of this. Now, my lord, tribunal has, my lord, gone on to reproduce that CBDT circular. My lord, have got it. That is appearing at paragraph number 5 of the impugned order.
So they say that the AO did not adhere to the standard procedure.
That is, my lord, the only ground by which, my lord, tribunal has gone on to deal with the entire thing.
But where is the AO's order?
I am showing that to your lordship. It starts from page 9 of the stay petition, my lord.
The respondent has been served?
Yes. And they were present when delay was condoned.
I think they have.
No,
Service has been filed. Affidavit service has been filed.
Where is Mr. Jinjunwala? He is not here today.
He's not here.
Morning they took adjournment, no?
Yes.
Because his name is not in the cost list. And who's the advocate on record, Anjan? No, we can we print the name? Yes, Mrs. Mitru Smriti Dattu. We can print the name. print the name of so and so in the cost list for the respondent list next week. If you happen to see him or his junior, you inform.
Yes, I'll inform.
Item number 25.
This is my application, my lord. Question of law at page 5, my lord. There are two issues. One with regarding to the depreciation, which was claimed by the SSC was disallowed by the assessing officer, and the second finding with regard to the unexplained cash credit. Now, here the SSC is a trust and established with the education for the purpose of education and charitable purpose. That was the primary object of the SSC. Now, before placing the order of the tribunal, may I place the order of the assessment? May I place the order of the assessing officer, my lord?
One second.
Page 9.
We'll just go through your questions.
Yes, my lord.
Now this 52 lakhs.
Yes, my lord.
Depreciation tribunal says that they have not claimed any depreciation in computation of total income.
If your lordship kindly comes to page 13, paragraph 5, my lord. That's a finding of the assessing officer, my lord. May I place it? The SSC had debited the depreciation amounting to rupees 52,70,000 from the income and expenditure account according to a review of the financial statement provided by the SSC. In this regard, kind attention is invited to section 11.6 of that. Now, that is the section quoted. Section 11.6 of the income tax provides that the depreciation shall not be allowed computing the income subject to the application against those assets which have been treated as application in earlier years. In view of the above, depreciation amounting to rupees 52 lakhs is proposed to be disallowed and the same is added to the total income of the SSC. A show cause notice was issued to the SSC to show cause why the proposed variation should not be made and accept or file your objection to the proposed variation. In response to the show cause notice, the SSC has not submitted any reply. Therefore, the same is disallowed as following. Further, as per the computation of the income provided by the SSC, it is noticed that the SSC has claimed rupees 52 lakhs being additions to the fixed asset as application of income for the purpose of the Income Tax Act. Further, the SSC has claimed the deduction of depreciation on the fixed assets purchased by it and capitalized in the books. In this regards, it is a trial law that no expense shall be allowed claimed twice under the income tax law, and thus the depreciation claimed by the SSC of the fixed asset is considered as the double deduction, and therefore depreciation is being disallowed and under section. This is the finding of the assessing officer, and this was upheld by the CITA, and the tribunal has dissented.
You just keep this side by side with page 32, para 11. Is it factually correct?
Yes, my lord. But may I indicate one thing? May I place the section once? But claiming twice is a double taxation.
The tribunal
Yes.
records that the assessee has not made any claim towards depreciation in computation of total income. Is it factually correct or wrong?
No, it is not factually correct because, my lord, the CIT's observation has to be taken into account.
So
My
show
lord,
the
kindly,
CIT
yes, my lord. Page 22, ground number 5, ground number 6, my lord. For the disallowances relating, no, my lord, ground number 5. For that, the claim of the appellant relating to the depreciation amounting to ought to have been allowed by the assessing officer. But now that the finding that comes, now if your lordship kindly comes to page 23. The AO, after examining the issues, found that the expenditure is being claimed twice, one under the head application of income and another under the head depreciation fixed assets. Thus restricted the disallowance only to the extent of the application, and the depreciation claim has been disallowed. The appellant thus claimed that in its submission that the depreciation is allowable on the fixed assets and has relied upon various case laws in support of its contention. The plea of the appellant has been examined and found that as per the amended provision of 11.6 with effect from 1/4/2016, the income of the trust should be determined without any deduction or allowance by way of depreciation and otherwise in respect of any asset, acquisition of which has been claimed as an application of income in any previous year. The Honorable Supreme Court in the case of the CIT versus Rajasthan and Gujarati Charitable Foundation had held that the amendment brought to finance number 2 of number 2 Act of the 2014 is prospective in nature. Accordingly, the disallowance made by the AO is upheld and the grounds raised are dismissed.
That's
so this
correct.
is, yes.
No, the mainly the AO said
They have interpreted the section
they
11.6.
have made a claim twice. But the tribunal says that they have not made a claim towards
But the
depreciation.
CIT has also upheld, my lord, the finding of the assessing officer.
Then how can the how will the tribunal record this? The learned AO erred in making disallowance of 527543 as assessee is not made any claim towards depreciation.
This runs contrary to the finding of the assessing officer, my lord.
What is that? Kindly, if my lord are pleased to take page 13, the paragraph 5. The assessee had debited depreciation amounting to 52,70,543 from the income and expenditure account, according to the review of financial statement provided by the assessee. So he's looking into the income expenditure account where it is debited. Now, the trust has different units. It has there's an account of the trust, then of the school, etc. So then it is consolidated. The consolidated amount of depreciation for all the institutions put together was 1 crore odd, which is the figure mentioned by the tribunal. This 52 lakhs is in respect of one of the institutions under this particular trust. So he is referring to that. The tribunal is referring to the entire amount of depreciation is 1 crore odd, which has been disallowed in the computation and has been not claimed as deduction. Previously, in the case of trust note, the amount spent on acquiring the asset was allowed as application of income. So also more of the depreciation. So there was a controversy on this. Our court's view all along was that one is entitled to both. Then the legislature stepped in 2015 to say that no, you will only get it once. You will not get the amount spent and depreciation both. So if the amount spent has been claimed, depreciation will not be granted. So and that amendment happened much earlier. Our year is 2021. So this amendment had come about much earlier. So this is what the reading of the tribunal's order shows, that this amount was added back in the computation. Therefore, there is no claim for deduction of this amount. Ideally, the computation should have been before, my lords. That would have cleared it up. So not that computation I'm not having with me, but I can get it, not if my lords
But
are.
in the grounds, not in the substantial question, in the grounds you should have, how have you challenged this finding?
They've sort of not accepted that particular finding.
Have you got the grounds of appeal filed before the tribunal?
I will also get that, no, it is, I don't have it.
But this amount is on account of the income and expenditure account, my lord. And that, on the basis of that, as my learned senior friend has also indicated, because the SSC has claimed it twice. That is the only moot question before your lordship. That is why the assessing officer, by invoking 11.6,
That the tribunal says is wrong. Factually, it's wrong. That is one issue. The other one?
and the other one is for that 84 crores, my lord.
8 crores.
8 crores, my
8
lord.
crores 40 lakhs.
Yes, my lord.
See, the
Lordship,
grounds
kindly-
of appeal, you should have raised a specific point with regard to finding rendered by the tribunal in para 11. You see your grounds. The thing is there. Sir, the one clarification, this 52 lakh 70,000 was part of the total claim of more.
Yes, but there are several institutions that at least 2 or 3 accounts were consolidated to make the common account which was filed.
Okay.
So this 52 lakhs is appearing in one of the accounts which was merged with the consolidated in the.
So then
and the consolidated figure is that 1 crore 2 which the tribunal is mentioning. But 1 crore 3 lakhs 75,142. That is the consolidated depreciation in that.
So in that 1 crore 3 lakhs, this
52 is included.
52, and that you have claimed.
That I have not claimed. The depreciation has not been claimed. When I've spent money to acquire the asset, I've claimed it. But when I'm depreciation, I'm not claimed because the bar under the law had come in to say that I cannot get depreciation also.
Specific ground they have argued. Ground number 7 and 8, page 32, para 9. Page 32, para
Because
9.
this partly covers, ground number 2 partly covers the finding at page 32, my lord.
No.
Ground number 2.
You please please take page 32, para 9.
Yes, my lord.
Paragraph 9. Last 5 lines. He further stated that while computation of total income and depreciation of 103,75,142 was not claimed, instead of the same was deducted from the total expenditure side, and it was not confirming part of expenditure applied towards charitable purpose. Therefore, the addition is wrong on facts indicated above. This the tribunal examined probably the computation and their statement of accounts, whatever they have produced, and found factually that they have not claimed. Because the AO's contention itself was you are not entitled to
Twice. Yes.
in terms of the statutory embargo.
Yes.
Under 11.6.
He mainly focused on that issue only. That cannot claim it twice.
And
but
the
did
other
not
one,
give it.
8 crores 40 lakhs.
That is for the donations.
But there they have given lot of
because
details.
Because for that particular,
Source they have proved.
Look, this came from another charitable
the
institution.
genuineness of that was not proved, my lord.
But the assessing officer
It's only
said,
the identity and the creditworthiness, but the genuineness is equally to be proved. That was not proved, my lord.
but the assessing officer said creditworthiness is not established. The commissioner appeal says the genuineness is not established. So, whereas the assessing officer was on creditworthiness, the commissioner appeal says genuineness is not established. The money has come from another charitable institution. Both are registered, and the donor trust also had institutions under it. So one of those institutions provided the funds to the head office gave the donation. So they're saying that that particular trust has filed a nil return. So it is exempt. It is under section 11, it's not being taxed, but its total receipts are 55 crores. The consolidated receipts are 55 crores, which is what the tribunal has recorded as part of the submissions.
Second point.
Second point, only page 12, my lord, paragraph 4.
No question of.
Because that particular did not exist also at that relevant year, my lord, because further on perusal of the, because it was not having any business activity. Further on perusal of the financial statement and various other information submitted by the SSE, it is noticed that during the current year, the SSE has only received donation from Narula amounting rupees 8 point. Further, the SSE has not received any donation either during the present assessment year or immediate preceding year, since the SSE failed to provide the creditworthiness of the party from which it has received the donation, and the said amount is added back. So since the conditions were not fulfilled by the SSE by showing that whatever the donation was given by that at that particular relevant point, assessment year, whether he had the institution had the capacity of giving the loan or not, or rather the donation or not. Even the bank statement has been reproduced in page 3. If your lordship kindly comes to page 13, my lord, the bank statement of the Narula Education has also been reproduced.
They are registered, this Narula.
Registered, but they have received equivalent or more sum. That is the finding of the assessing officer going through all the statements, because they have not been able to verify the transactions. And now the finding is that in lieu of the payments made by Narula to the SSE, Narula has received equivalent or more sum from third parties through check. And those appears from the bank statement, my lord. There further, it has been noted that the bank statement reproduced above clearly reflects that the payment to the SSE by Narula is made through a corresponding receipt by the trust. Further, no balance confirmation from the party has been provided.
There's no substantial question of.
Well, it's not third parties. It is the dental college of the Narula Education Trust, which is transferred.
Education
Because at the page 24 also the CITA.
Narula Educational Trust, registered in 99, runs 2 institutions. One is a technology institution.
Engineering.
Another is a dental institution. And the gross receipts for the trust for year ending 31/3/2020 was 55.93 crores. And in response to the query, they have produced it. And before the, tribunal also, they produced this. In fact, source has been proved. And source of fund. And how Narula.
But at that relevant assessment here, there wasn't any income, my lord, because from the bank statement.
Some hanky-panky was there. By now, Narula would have come to the court against cancellation of the 12A registration.
But page 24, Commissioner Appeals, not the penultimate paragraph.
Yes.
He says that the
genuineness,
identity and creditworthiness have been demonstrated. So he is on genuineness.
Though the identity and creditworthiness have been shown to have demonstrated genuineness.
Yes, but that is equally to be proved. And my lord, there is a judgment of the Madras High Court which shows that only this identity or creditworthiness will not do, the genuineness has to be proved. And I have shared that judgment, my lord.
Let us see.
And in respect of that 11-6, there is another judgment of the Supreme Court that also I have shared, my lord.
Please
Both the
open.
judgments I have shared. This one is with regard to this is the Madras High Court with regard
Oh,
to
no,
that
Mankai Lal,
genuineness and the creditworthiness, my lord. That genuineness is equally to be proved.
Not working. Edisha, I think you have to change the battery. All right. You scroll the judgment to head note alone, you show.
So, put
Head.
head note के छाड़िए.
Which paragraph you want us to see?
10, my lord. One another point which was pointed by the department was that merely because the loan transaction was sought to be relied upon by the SSC as the transaction was given by check, by itself will not prove the genuineness of the transaction or for which the reliance was placed upon the judgment of the Calcutta High Court in the case of United Commercial, which was also relied upon by the tribunal, which categorically states that the SSC must prove not only the identity of the creditor, but their creditworthiness and the genuineness of the transaction has also to be proved beyond any reasonable doubt by the SSC. In this case, the SSC has miserably
Identity alone is not correct. There's no quarrel to this
and
proposition.
then subsequently, if your lordship kindly takes a paragraph 10, there is another judgment which
Yes,
has been relied
Calcutta.
upon of the Calcutta High Court came to the conclusion as rightly held that the burden of proof of the genuineness, the SSC must prove not only the identity, capacity of the creditor to advance money and the genuineness of the transaction, mere proof of identity of creditor is not sufficient.
Then what is
And
that?
with regard to that 11-6, my lord, arakta আছে আমি Supreme Court দিলাম. That it is prospective in nature, my lord.
There's no quarrel. Nobody is disputing it. All right, please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 21/3/2024 passed by the Income Tax Appellate Tribunal B Bench Calcutta within bracket Tribunal in ITA number 1313/KOL/2023 for the assessment year 2020-2021. The revenue has raised the following substantial questions of law. Page 5, A and B. 2 questions only, sir. We have heard so and so, so and so. The respondent assessee is a trust established with the established for educational and charitable purpose as its primary object. The trust filed its return of income on 10/1/2021, declaring the total income as nil. Subsequently, notices under section 143 within bracket 2 and 142 within bracket 1 were issued to the SSC along with questions. The assessee responded to the notices and furnished details and documents. The assessing officer completed the assessment by order dated 29/9/2022. Under section 143 within bracket 3 read with section 144 capital B of the Act. Among other things, holding that there is a variation in respect of addition on account of unexplained cash credit under section 68 to the tune of rupees 8,40, 00, 000, and variation in respect of addition on account of depreciation under section 32 to the tune of rupees 52, 70, 543. The assessee filed an appeal before the National Faceless Appeal Center within bracket NFAC. The appeal was dismissed by order dated 5/10/2023, which was challenged before the tribunal. The tribunal, by the impugned order, has allowed the appeal and agreed by the same the revenue have preferred the present appeal. Two issues arise for consideration. Firstly, whether the assessee had claimed depreciation of rupees 52, 70, 543 twice. The assessing officer came to the conclusion that the assessee cannot be allowed to claim depreciation twice in the light of the amended sections 11 within bracket 6 of the Act, and accordingly made the addition. Before the tribunal, the assessee contended that while computation of total income and depreciation of rupees 1,03, 75, 142 was not claimed, instead the same was deducted from the total expenditure side, and it was not confirming part of expenditure applied towards charitable purpose. The learned tribunal verified this factual position, examined the computation of income and other accounts and the books of accounts, and held that and found that the assessing officer erred in making disallowance of rupees 52, 70, 543, as the assessee has not made any claim towards depreciation in computation of total income. The revenue has not been able to establish before us that this factual finding is incorrect or otherwise. Therefore, we find no grounds to interfere with the finding rendered by the tribunal in this regard. The next matter concerns an addition made on account of unexplained cash credit to the tune of rupees 8, 40, 00, 000. As could be seen from the impugned order, the assessee had responded to the questionnaire and produced all documents. And those documents were also placed before the learned tribunal in the form of a paper book. On going through the findings recorded by the learned tribunal, we find that the assessee has not only proved the source of the funds of the donation, but also proved the source of source. The Narula Educational Trust, which enjoys a registration under section 12 capital A of the Act since 1999, is the donor trust, and they run two educational institutions, one being an engineering institution, one being an institute of technology, and other being an institute of dental sciences. And the gross receipts of Narula Educational Trust for the period ending on 31/3/2020 was rupees 55.93 crores. That apart, the tribunal also noted that the assessee, during the course of assessment proceedings, responded to the show cause notices issued by the assessing officer and produced all documents showing payments were made by Narula Educational Trust to the assessee. At this juncture, it is to be noted that the assessing officer was of the view that the genuineness of the transaction has not been established. However, the first appellate authority, while affirming the assessing officers, while affirming the order of assessment, held that the identity and creditworthiness of the assessee of the donor trust was established, but the genuineness of the transaction was not established. Thus, both authorities were not clear as to on which ground the assessee should be faulted. Nonetheless, the learned tribunal has done the factual exercise and has been satisfied that the assessee has been able to prove the not only the genuineness, but also the creditworthiness of the donor trust. The identity and creditworthiness of the donor trust. Thus, we find no question of law, much less substantial question of law, arising for consideration in this appeal. The appeal fails.
Agreed.
May I have my lord's indulgence, my lord? I'm being led by my Mr. Bhattacharya, senior counsel. He's on the virtual mode.
My lord, under compelling circumstances, I'm mentioning a matter, my lord, which was listed before Justice Rao and was fixed at 3:45 p.m. today. My lord, the interim order is expiring today, and my lord, Justice Rao, my lord, didn't sit after 12 noon, and there was no notice published. The interim order is expiring. It's in a suit for infringement and passing off. The interim order has been continuing from 19th of August, 2024.
What can be done now?
Lordship.
Now you have passed a resolution that we should not be sitting after 3:30. In fact, we have violated your resolution. We are sitting till 3:40.
My lord, I tell your lordship, my lord, even day before there was a resolution, but Mr. Chaudhary, Jishnu Chaudhary and we were there before Justice Rao, and we said, if your lordship is willing to take up the matter, and we argued the matter till 4:40.
Now, what to do?
If the learned judge,
if the honorable judge was not available, you could have made a mention at 10:30 itself, seeking for extension.
No, my lord, my lord, the honorable judge was sitting till 12 o'clock, but there was no notice that he's not going to sit after 12 noon.
We don't know what the circumstances made his lordship not able to sit. But then the other side is not there on the administration.
We have informed the other side. We have informed the other side.
We have informed the other side. I had called the other side.
And the administrative side, what can be done? None of the judges will be available now. Everybody would have risen for the day.
Lordship, it's a dire circumstances where my interim order is getting expired.
Between today and Monday, what will happen, Mr. Bhattacharya? Between today and Monday, we can ensure that the matter is in the list on Monday.
Lordship will kindly grant that. That will be great.
No, it's serial number.
9 and 10.
9 and 10 in today's list.
You do one thing. You give this letter to my OSD.
Lordship, I do not have a letter. I have the last order by which the interim order was extended.
Whatever Mr. Bhattacharya has submitted,
I'll write that in a letter.
We were about to mention, but however the court
because your lordship, my lord Justice Rao's practice is that at the time of rising, if the interim order is expiring, he extends the order. But we had no indication that he's going to rise at 12 today.
All right. Exigencies come, sir. Some advocates come.
I do realize. I do realize. I am not saying anything.
Suddenly, some emergency there.
No, my lord, that happened to me.
Sir, he came at 10:30. 11 o'clock, he had to rush. There is a medical emergency in his house.
No, my lord, that's what has happened to me today, my lord. I was in court in the first half. My daughter, who is 3 years old, she was not well. She was cranky. And my house help called me up and said, please come back home. That has happened to me, my lord, today.
So nothing to, you just say Because the quote is not available, we could not mention. Don't say no notice of this, that.
No, my lord, I will not say that. I will not say that. I will not.
Request for appropriate directions.
Very well.
So I will say that the matter be listed on Monday under the caption for extension of intermodal.
Grateful, man.
Grateful, my lord. Grateful.
Deeply obliged.
My lord, and you do one thing. You draft that letter, sign, serve a copy on the other side.
I will serve a copy on the other side as well. I'm grateful.
And who appears for the other side?
Mr. Ranjan Bachawat.
Mr. Ranjan Bachawat, my senior Mr.
My lord, I don't know whether you would have consented for extension.
No, my lord.
It's continuing from 19th of August.
My lord, we have been hearing this extensively.
But this has been extended several times, my lord. Several times.
You can't serve on Mr. Bachawat. He's
No. Mr. Tonmoy Rai is the advocate on record.
Mr. Tonmoy Roy is the advocate on record. I had called him. He said that he has some difficulty. He can't come. But I had called him. The time was not there because we knew it was 3:30 and
But
we had to go to.
that camaraderie matters can happen. We can argue that camaraderie is there between us.
No problem.
I'll
Grateful,
send. Grateful.
My lord.
Much okay.
My lord, item 56, my lord. May I request, my lord, it was a appeal filed. No, my lord, what I'm requesting is that, my lord, on the next date, if it can be kept little higher on the board. Because
Next date, nothing will reach because two appeals, AG is appearing. That itself will go on if you want.
Then, my lord,
This
on
is
Friday,
that,
next Friday.
Advance ruling matter.
Yes, my lord.
Advance authority ruling matter, that matter?
No, not advance authority, my lord. It is a matter, my lord, against the sestet order. In the meanwhile, the matter was remanded back. And thereafter, the concerned authority has issued a notice for adjudicating on the matter on remand. Whereas we have filed an appeal, my lord, before your lordship.
Remand is open remand or what?
Open remand.
And you're questioning the remand?
I'm questioning the remand also, my lord, the limitation, my lord, extended period of limitation.
That also you can canvass.
My lord, what we are canvassing, that extended period of limitation has been upheld, which we challenged. So that also is in appeal, my lord.
Oh, that finding has been upheld.
Yes, extended period of invocation of extended period has been upheld by the sestet, and which is also we are challenging before your lordship.
And after upholding that, they sent it back.
After upholding that, they sent it back.
But you said it's an open remand.
Open remand means all the issues. There are 3 issues for taxability under different heads. So that is an open remand to examine all the documents and all that.
But this extended period can't be re-argued.
That can't be re-argued. And my lord, all the documents were before the honorable sestet and the
who will appear for the department.
My lord, that we are not aware of, my lord.
You have to
Mr.
find out.
Tapan
Banja or Kaushik Dev.
Mr. Kaushik Dev probably.
Kaushik Dev will be there, or
Kaushik Roy.
Ekta Sinha.
Yes, my lord.
Or Ekta Sinha.
Yes.
EKTA. Madam is here.
Mr. Tapan Bhanja is there.
And probably. What is her name? Mansi Mukherjee.
No, Mr. Tapan Bhanja, my junior is saying Mr. Tapan.
Where is he? He is not here today.
He is not here.
Next week, let it remain in the list. Let us see. Next week, because we have fixed this matter, we started hearing. That will take some time. That is serial number 11 and 12 today. That will take some time.
If it just can be, my lord,
we have adjourned. Huh?
Kept little higher on the board, then probably there will be
You're
greater.
Already very high on board.
Lord, 56.
No. Interest is seniority. You see, sir. We for admission, custom matters start from 43. You are 56.
56.
High on board. Normally, what we do is we rotate. We put custom matters and sexa matters on top only, income tax next, so that everybody gets a chance. No, next week you won't get
last
a chance.
2 weeks, my lord, only IT matters are on the top.
Yes. Because budget has come now. Let us collect some tax. Let it remain.